for delivery of judgment. Item number 38, criminal petition 285 of 23.
Petition allowed. Proceeding first.
Item number 39, criminal revision petition 399 of 23.
Petition dismissed, being not maintainable.
Item number 40, criminal petition 988 of 23.
Revision petition dismissed. Yes.
Prosecutors. I'm requesting for an urgent listing of two anticipatory bails, Your Lordship. If the clients are from Bombay and the transit bail anticipatory protection is expiring on Monday, I'm only requesting Your Lordship the matter be listed tomorrow. There are two applications of my client have been filed.
Tomorrow.
Tomorrow, Your Lordships. I'm extremely grateful.
The same prayer lordship, so by tomorrow, one year lordship. So
When?
20 days custody in the same lordship.
When to be listed?
By tomorrow, lordship, possible lordship.
Kabir, how many matters are listed tomorrow?
For tomorrow, Lordship.
46. Okay.
Please, Your Lordship. Actually, for listing and criminal appeal on 11/1, my Lordship.
When?
11/1
11.
of last month.
May I please, Your Lordship?
Yes.
I beg to mention for listing a criminal appeal lordship.
When?
Next week, any date, lordship.
Next week.
Any date.
Okay. Monday?
Monday on 8.
Yes.
Criminal revision petition is pending case, my lord. It is as per the order. So my plan it may be taken on 9 January.
9.
Right.
Okay.
May I please, Your Lordship? I beg to mention for listing of two bail application for withdrawal, my lord.
12. When?
Withdrawal from my only prayer unlisted may be taken at 2 p.m. my lord.
Today?
Today, my lord.
Not 2 p.m. as a last item.
Last item, my lord.
May it please your lordship.
Yes.
I beg to mention for listing an AB for motion for tomorrow, lordship. Motion.
Tomorrow?
Lordship.
Okay.
Oblige your lordship. Listing of the bail hearing, Madam Lordship, it was left over on 21 PL, lordship. On Monday, lordship.
When?
On Monday, lordship.
Monday? Okay.
May I please? I beg to mention item number 18, lordship, 1A. This matter, lordship, my senior Mr. Kanjada through Lakia, lordship. But today he has some personal difficulty, lordship.
Hmm.
Matter may come up on Monday or Tuesday.
Monday?
Yes, sir.
Okay. What is your name?
A.S. Ali.
On the pair being made by Mr. A.S. Ali, Learned Counsel for the applicant, list the matter on Monday. On that day? Oh, no, this is LCR was called for.
Yes.
Okay.
Lordship, I beg to mention item number 33. Daily list.
Yes.
My senior Mr. P.K. Karode is out of station, lordship. Let the matter be fixed after.
What is your name?
D. Sharma.
Item number 33.
30.
Garudia's name is not there.
Today is not shown his name.
Your good name?
D. Sharma.
Your name is also not
I am
there.
appearing on behalf of H. Vetala.
So this matter was adjourned on several occasions. Why?
No, already hearing was conducted.
That's all right.
Your Honor.
But why repeated adjournments are being taken?
At Nogao district, Your Honor. Today.
Pardon?
He is out of station, lordship.
Always he is out of station.
Let the matter be fixed on due vacation, lordship. Just after due vacation.
No, before. Kabir suggest on that. On Tuesday?
On 11 Thursday.
Obliged, lordship. May I please?
On the pair being made by Mr. Your good name?
D. Sharma.
Learned Counsel for the appellant. List the matter on Tuesday.
On Thursday 11.
Thursday. Okay. Thursday 11.
Obliged, lordship.
May I please, lordship? My lord, I am trying for listing of a case, my lord. This is my lord, long pending case, my lord. So my lord, kindly maybe taken up, my lord, 9th January.
Of which year?
23, my lord. It was last listed on 5th 3/2023, my lord. service is complete, my lord, for admission, my lord. So,
When to be listed?
9 January, my lord.
9th.
My lord.
Okay.
Another matter is there, my lord. So this is service is complete, my lord. So this matter may also be listed, my lord.
Lordship, after vacation, one after vacation.
Lord,
So,
this is my lord, 8
um,
January, my lord.
okay,
Obliged.
May please, I get to mention on criminal revision petition, lordship,
yes,
that may come up for orders, lordship, on 9,
9th.
on 9.
9th,
After vacation, Lordship. Too many cases before vacation.
after vacation then.
Special lordship for orders, the case is fixed.
Now, is there any urgency?
Yes, lordship,
What urgency?
this case is fixed before the POCSO court on 19 lordship. And there was an interim order
19th of this month.
this month, lordship. And prior to
So
that,
we
I
will
need
take
to-
it up on 18th,
18,
18th.
lordship.
May I please, Lord? My lord, item number 22, perhaps diary not received. Kindly pass over the matter. Item number 22,
22.
my lord. Perhaps diary not received.
On the pair being made by Mr. A. Parmanik, learned counsel for the applicant, list the matter on
Kindly prior view.
when?
After view,
Prior view. Prior view.
on 12, Lordship.
12.
Highly.
Okay. On that day, learned additional PP shall produce the case diary before the court.
May I please, lordship, lordship, I beg to mention item number 10.
Yes.
Kindly attend the matter today. My clear counsel is one family member.
Lordship,
of
CD is there, item number 10.
CD is available.
Senior counsel, one family member is hospitalized.
Who is your senior counsel?
F of
Your name?
M.
Mr. N. Islam, learned counsel for the applicant submits that Mr. F. Hawk, learned counsel is out of station on account of illness of one of his family member and prays for listening the matter on Monday then? Monday, okay.
I left.
Till then, case diary be retained.
May I please, lordship, lordship, I beg to mention item 15. Kindly matter.
Item
15, 1-5.
15.
Kindly matter be passed over for the day and may come up after the vote election.
Why?
There was some personal difficulty.
Personal difficulty of
Lordship,
your personal difficulty.
sure. Lordship,
What is your name?
R. Akhtar, lordship,
R?
R. Akhtar,
Your name is not here.
on behalf of S. Munir, lordship,
S?
Munir.
When the petition was filed?
We have received the CD in item number 15.
When the petition was filed? Paperless adjournment. 8-7. No. Since the case diary is available, we will hear you. We will call the matter.
No mention, next two.
May I please, lordship, lordship, I beg to mention DA number 4649, public 2023. Lordship, I may allow, kindly may allow to. Yes, some
When?
documents was not annexed, lordship.
When?
Tomorrow.
Tomorrow.
Diploma.
May it please, your lordship, I beg to mention for an anticipatory bail application for tomorrow morning.
When?
Lordship,
When?
tomorrow,
Tomorrow.
yes, lordship, much obliged.
May I please, lordship, I beg to mention for listing on criminal petition, lordship. Kindly list the matter on 10th of January. lordship.
10th.
May I please, your lordship, I beg to mention for listing of a criminal appeal on 19th January.
May it please, your lordship, I beg to mention an appeal for hearing, my lord. The last occasion, my lord, it was directed, my lord, the matter may be listed in the first week of January, my lord. But tomorrow also, my lord, the matter was not listed. So
Acha. When do you want?
tomorrow is the last item,
Tomorrow?
or Monday or Tuesday.
No, tomorrow is not hearing day.
Then Tuesday or Monday, my lord.
Kavit.
Thursday, 11,
11, before that,
9.
9.
9.
Okay.
Highly okay.
May I please? On bail petition, my lord, under section 438,
Hmm.
my lord, urgency is there. My lord, can it be, my lord, posted tomorrow, my lord?
Tomorrow. Okay, we'll try.
Item number 41, motion bail application.
It is your lordship, a 439 bail application, lordship. 20 days behind the bar, lordship. FI is at page 10, lordship. Can I go through it here, lordship? Page 10 annexure A.
From which PS?
Lordship, Vishwanath Sarali PS.
Yes.
Sir, with due respect, this is to inform you that today at around 7 PM in the evening, the opposite party, that is the petitioner, had physically assaulted my brother-in-law, Sri Kamal Das, by giving him 2 blows in his face, for which he got injured, and to lodge a case against the opposite party, I along with him went for Vishwanath Sarali police station in the scooty bearing number so and so. But the opposite party, with the intention to hurt us, followed us in his 4-wheeler vehicle from the backside and hit our scooty and fled away. It is to be mentioned that due to the grievous injury sustained by my brother-in-law, Sri Kamal Das, he was immediately referred to the Tezpur Medical, and at present he is fighting for his life, lordship. It is merely an accident, lordship. 307, 326 is added, lordship.
Lordship, case I be called for along with the injury report, medical report, man.
But though the case was registered under section 326 IPC,
307.
there seems to be no material from a
The
perusal of
injury
that.
report will reveal, your lordship. Let the
20
CV
days
come.
already behind the
No, madam, you see, there is allegation of fist blow.
Then thereafter, my lord, mentioned due to the grievous. Lordship, may I take your lordship to the vernacular?
Yes.
Can I go through it?
Lordship, Assamese portion at page 14.
Is there any
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি সন্ধিয়া 7 মান বজাত উপৰোক্ত অপৰপক্ষজনে মোৰ ভিনিহিদেউ কমল দা পিতা শ্ৰী দেহিৰাম দা দক্ষিণ ভিৰগাঁও থানা বিশ্বনাথ চাৰিআলি মূল দুটা ঘুষা মাৰে ফলতে আঘাতপ্ৰাপ্ত হয় আৰু মোৰ সৈতে AS32 সয়ঞ্চো স্কুটিৰে অপৰপক্ষজনৰ বিৰুদ্ধে গোচৰ দিবৰ বিশ্বনাথ চাৰিআলি আৰক্ষী থানালৈ ৰাওনা হওঁ কিন্তু অপৰপক্ষজনে আমাক পিছা কৰি আহি তেওঁ চাৰিচকীয়া বাহনেৰে আমাক হত্যা কৰাৰ উদ্দেশ্যে পিছফালৰ পৰা আমাৰ স্কুটিখনক খুন্দা মাৰি তাৰ পৰা পলায়ন কৰে ফলত আমি দুজন গুৰুতৰভাৱে জখম হওঁ উল্লেখযোগ্য মোৰ ভিনিহিদেউ শ্ৰী কমল দাসৰ জখম বেছি হোৱা তেওঁ তেজপুৰ মেডিকেললৈ তৎক্ষণাৎ প্ৰেৰণ কৰা হয় তেওঁ বৰ্তমান মৃত্যুৰ যুঁজি আছে
So it is merely an
The
accident.
lordship, the subsequent portion.
Already 21 days behind the bar, lordship. Till there. At best 279.
so where is the material to show the ingredients of 326?
Lordship, because of the heat, my lord, so the injury report will reveal, your lordship.
It is by hand, lordship.
No,
It's basically
then
still-
thereafter, your lordship, while the vehicle from the backside and hit our scooter and played away.
Okay, on Monday you produce the injury
Lordship,
report and the case diary.
Biswanath Sariyali, my lord, today is
Yes,
Thursday. Can it be on,
five
Mangalore?
hours journey from here,
lordship?
5 hours journey from Guwahati.
Lordship.
Vishwanath Sarali, 5 hours journey from
Oh,
Guwahati.
yes, okay.
Lordship.
Not Tuesday or not on Monday? Can it be on Tuesday?
Tuesday.
Lordship.
No, Monday then.
My lord. Monday.
CD and injury report of the victim.
The sections are not affected here, lordship.
Pardon?
Sections are not affected here, lordship.
No, we will see the case diary whether 307 is attached or not. Otherwise, there is no material of section 326.
Lordship. Oblige.
So items for admission, 1, 2, and 3.
In this case, by order dated 13/9,
Yes,
we are permitted to bring some additional documents
yes.
on record. For that, we have to file affidavit. The affidavit is in transit, lordship, because these persons will find it very difficult to identify because they are all retired officials of ONGC.
Yes.
So by Tuesday, we'll file the affidavit, lordship. And thereafter, lordship may fix up the matter for final disposal. These are 482 applications for quashing of complaint case before the magistrate.
On the pair being made by Mr. D. Soikia, learned
Senior counsel.
senior counsel, list the matter on Tuesday.
Thursday next for disposal, by
Thursday.
Tuesday we'll file the affidavit,
Thursday.
but next
Okay.
Thursday.
Lordship, next Thursday, let it come up after the Bihu vacations. I have personal difficulty.
No
Yes,
difficulty,
yes.
Lordship.
Okay.
After the Bihu vacation.
After Bihu vacation,
Then
it's
suggest
on
that
23rd then,
23rd.
23rd,
Okay.
deeply obliged.
Okay.
Item 4,
For indicate petition mallet for quashing the affair.
Hmm.
So she kindly see the affair is a pest still. Page 16.
Where is the page number?
16. The allegation against the petitioner that they have forcefully custodied the petitioner.
Yes.
Yes, according to Nirmala, the incident had taken place on 10th of April 2019,
Hmm.
and she has lost the affair on 13/7/2021. Now, your lordship kindly see. for
Oh,
this
what
time,
is this? Page number 22?
Page number 22. This is another affair. There was a conflict between two group of genders, my lord.
Hmm.
Now, your lordship kindly see. For this procedure, my lord, she has to undergo a surgery. There are certain procedure. Your lordship kindly see NHS C, page 24.
Hmm. Page?
Page 24, NHS C.
Yes.
The patient RO F1 Calcasia 13/3/2009 was born naturally as male but had gone diagnosis with natal sex since childhood and so would be seen as female. The patient lived alone and has living in gender community for the past 4 or 5 years and now wants to get SRSGS done. And long then consequence of the same since any parts MO, physiotherapist illness, anxiety, substance, so and so. Thereafter, again, made an NHS. This is the certificate issued by the doctor. D. Hormone therapy. He was taking hormone therapy for the last 1 year. NHS D. Thereafter, another NHS mirror, NHS E. He has been found fit for surgery. And after that, the surgery had taken place.
Hmm.
It has been explained that that is not possible. And now, my lord, they have filed affidavit, my lord. In their reply, they have admitted, my lord, she has lost the affair under the influence of someone else. Your lord, she kindly see their affidavit in opposition.
Page number?
Yeah, my lord, 5, 6, and 7 is
When?
in their affidavit in opposition. My lord. paragraph 5, 6.
Madam, you have no objection.
No,
Yes,
Lordship,
madam?
I am told of inside was confirm, my lord.
Is it?
Yes, it's on its way, your lordship, after some time.
Acha.
They have no objection. It's election, they cannot take the law in their own hand. Now they are saying out of,
So, you want the matter to be adjourned today?
no, it's coming from our office
Okay,
after some
well,
time.
okay, then at 2 p.m. 2 p.m.
Yes.
Item 5.
Please, your lordship.
Lordship, kindly pass over the matter for time being. My senior is on next in another court.
Okay, at what time he will be available?
Lordship, after some time,
After some time. Okay.
Oblige.
much of it.
Item 42.
Comment program.
Here the petitioner read is here the present petitioner is impleaded as an accused in this case. And the present petitioner has challenged that order in my wish. Present petitioner has been arraigned as one of the accused under 390. Now pending this case, some new development has come place.
No,
And-
yesterday you have submitted about this, about that,
Yes, Lord.
that the other accused persons were acquitted.
After along with the petitioner's name also has been mentioned in the, I have provided a copy.
Mentioned in the judgment.
Yes, sir.
Which part?
Uh, After.
No, whether his name is mentioned in the operative part of the
Yes, yes.
judgment.
Yes, Lord.
That paragraph number?
What's para. First page, Lordship, para later on, Lordship, last bottom part, Lordship. And in the main judgment, Lordship. Judgment, Lordship, last para page 11, Lordship.
Para?
Para 19.
What is the name of the petitioner?
Fully Goswami.
So, madam, where is the case?
Yes, my other face of it, but she did not face trial. Because the stay order was passed by this honorable court.
Hmm.
Because your lordship on 313 was brought in, your lordship. And against the order of implement, your lordship stayed by this honorable high court,
Honorable.
lordship. So. No trial faced by Kakvali Goswami, your lordship.
But her name is there in the operative part
order
of the
portion,
judgment.
yes,
But
but she
unless you
was- she
challenge
was
this
faced a
judgment,
trial.
She has not faced. So for the rest of the accused persons are concerned, your lordship, it is directed that the rest, that the prosecution may be continued against rest of the accused person. Other than your lordship, the Kakvali Goswami petitioner, the present petitioner.
Her name is mentioned,
Mm.
But she is an accused, but since the proceeding has been stayed by this honorable court,
Mm.
she has not faced the trial.
And that's all right, but whether that was brought to the notice of the court below?
Lordship, it was observed, Lordship, the first page, Lordship, second paragraph. Accused apology impeachment has been stayed following an order of the Honorable High Court.
Mm.
The first page of the order.
Acha.
Lordship, there, it was in the knowledge of the court.
So what to do?
Lordship, one of the factors your lordship will take into account, she has not faced the trial. Other person, although her name is mentioned by the learned court below,
Mm.
and she was also acquitted from the charges, but she has not faced the trial. That aspect, the final point is there, your lordship.
So can we draw up a summatory revision petition against this against this judgment?
Yes, your lordship may. Because she has not faced the trial, her proceeding has been stayed.
Mm.
So your lordship, we are mentioning her name in the this one order,
Mm.
maybe an irregular order, I know.
So if the prosecution have failed to prove the case beyond reasonable doubt, that's the different matter altogether, your lordship. That's the different matter altogether. But so far the present petitioner is concerned, your lordship. Since your lordship, state has been granted, your lordship, by this honorable high court. So against the petitioner, this prosecution cannot be continued, your lordship. So far the others are concerned, your lordship, that is loud and clear, your lordship, from the order itself.
He may approach the learned court below.
Email.
Lordship,
She may.
Lordship, since my case is pending here, it may be decided on merits here, Lordship, because honorable judgment of the Supreme Court, Hardeep Singh, Lordship, clearly states, a constitutional based judgment clearly states that before adding a person or impleading a person as an accused, Lordship, there should be sufficient material so that prima facie materials, more than prima facie materials is needed for impleading a person.
Mm.
But the question is that can the trial court, your lordship, travel beyond, your lordship? Where the state more specific, more particularly is against the petitioner, your lordship. Can the trial court travel beyond this without there being any
Lordship,
trial?
That is a technical point, but if the lordship decides on merit, lordship, there are several Supreme Court judgments which says that is 319 section should be used very sparingly and only in those circumstances where where the
So what is
accused
that
person
order 319?
Order 319.
Page 36, lordship.
Page 30?
6, lordship.
36.
Annexure 7.
Lordship, can the LCR be called for and let the matter be decided here? After perusal of the evidence and record?
Lordship.
LCR was not called for earlier.
Lordship, LCR.
No, LCR is available here. Madam, then you go through the LCR.
So lordship fixed is for necessary order, your lordship, then you after going through the LCR, your lordship.
Lordship,
Or by today itself, your lordship.
Pardon?
Lordship, since all LCR is available, your lordship.
Yes.
So maybe fixed for some other day for necessary order, your lordship. Or you lordship.
No, it has to be fixed for hearing.
Lordship.
So, where is the evidence of those PW1 and PW2? Madam, you please go through the LCM.
The evidence of PW one and two are at page annexer 5 lordship, annexer 5, page 29. PW one is at page 23 lordship, annexer 4 lordship.
Only information in question of this.
I'm the informant of the case. Lordship, may I start?
Page number 23.
23 lordship, and for informant, statement of the informant. Page number 29 lordship. Is the statement of the victim person from whose account the money has been siphoned off.
Then where is the material against the present petitioner?
There's no material.
Pardon?
There is no material as of the person.
Then where is the question of invoking
Now
the jurisdiction under section
Lordship,
319?
Only submission is restricted to your lordship. Since the proceeding against the petitioner is stayed by this honorable high court. So can the trial court, your lordship, but the case is not been finally disposed of in this honorable high court, your lordship, can the trial court travel beyond this in passing the order acquitting all the accused persons. Your Lordship.
No, in this petition, the challenge is the order under section 319 of the CRPC, right?
Lordship.
We will examine only that aspect only.
Yes, Your
So
Lordship.
whether
And
the
see-
trial court is justified in invoking the jurisdiction of 319 CRPC,
Yes, that
is there any material?
Yeah.
If there is no material, the matter ends there.
But Your Lord, she's a branch manager of the bank.
Yes,
According to the victim PW2, who has been died subsequently, no ATM card was issued in her favor. She only gave her thumb impression and used to take out money. Lordship, she
Yes.
didn't have any, but from her account and the amount which is deposited was the freedom fighters pension,
Mm.
which was.
No, that's all
Yes,
right.
my lord. So it
But
was withdrawn.
where is the material against the present petitioner?
Yes, that is, your lordship has to look
Lordship,
it.
There
take into account.
a name has been taken, Lordship, manager is Rupam Bora. And I know the name of the cashier. Only this much has been revealed by the victim or the person who from whose account has been. The question may have been asked in that terms that how does she, since she is a illiterate lady, how does the person withdraw the money?
Lordship, that aspect your lordship rightly has held 319 whether it be applicable against the
Lordship, that's-
petitioner.
Mm.
Because she is the branch manager of that bank. So lordship probably rightly the honorable trial court has issued the order for implement of her as a.
Lordship,
For
Rightly.
Yes.
for
Lordship-
proper adjudication of the Your Lordship, maybe for effective
Lordship, the
adjudication
wrong
of the
person
case.
has been implicated.
It will-
No, the question is on what basis? Where is the material? Whether the two witnesses have whispered any word against that petitioner?
Only this one, the victim has said the bank employee, মোৰ মতে bank আৰু bank কৰ্মচাৰী দায়ী মই নিজে পঢ়া শুনা নাছিল।
I have not seen. I went to bank and withdraw money. The manager told that I have sent it from this account. I don't. The victim statement, Your Lordship, directly not implicated the petitioner, Your Lordship.
Yes.
So far, after recital of the, Your Lordship, the deposition of Bimola Guhai, the victim is concerned, Your Lordship. It's not directly implicated, the petitioner, that because of him or he directly involved in siphoning the money, Your Lordship. That is not clear. That's not it.
Then,
Then Your Lordship, Lordship, so far the order passed.
mm,
Whether invocation of 319 is justified in the eye of law, in pleading the present petitioner, that has to be looked into, Your Lordship. That is the only thing.
mm,
So far my understanding is concerned. Your Lordship.
yes.
Otherwise, Your Lordship, after perusal of the statement of the victim,
Mm,
there is no whisper at all that he has misappropriated.
mm.
She has misappropriated money.
And where is that judgment of Hardeep Singh?
Deep Singh is a long document.
No, but if we go to the order, impugn order, where the learned court below has recorded its satisfaction that materials are there against her. Impugn order is at page number
Page number, Lordship. Page number 36, Lordship.
36.
36. No reason has been provided.
So here in the order dated 28/1/2019, page 36, Your Lordship.
Mm.
Although no order, no reason was assigned to Your Lordship in the order.
Mm.
But
No,
after-
merely on the basis of the petition filed by the learned additional PP, the court below has implemented the same, implemented the person concerned. Hmm?
No, it is Lordship, it is after examining the PW 1 and 2, Your Lordship.
Mm.
On being prima facie satisfied after examining the PW 1 and 2, that
Where
there
it
are
is mentioned?
there are certain materials to bring the accused petitioner.
No, where is that reasoning in the order?
Reasoning is not assigned to Your Lordship.
Then
Reasoning is not assigned.
then
আমার objection আমার objection তো respect করিব লাগিব physically 319 দিলাম Lordship,
mm.
my respectful submission before you, Lordship. Although in order dated 28/1/2019, no reason was assigned as to how he was brought in, impleaded under section 319 PRPC. But the thing is that, Your Lordship, since this order has been stayed by this Honorable High Court, Your Lordship, so the trial court has traveled beyond, because so far the rest of the accused persons are concerned, Your Lordship. The trial court could have passed the order, but so far this present petition is concerned, Your Lordship. There is the bar. If you, in spite of that, if Your Lordship pass an order, Your Lordship, then our objection, Your Lordship, has to be reflected in the order.
What objection?
Objection is that, Your Lordship, that we have raised the objection that the Honorable High Court had stayed the impugn order dated 28/1/2019.
No, that is not the issue before this court now. We are on the merit of the petition. Whether there is any material to implead the petitioner.
Merit on the petition of the petition dated 28/1/2019.
Mm. Yes.
It was PW2's evidence was recorded in 28/1, my lord.
Mm.
So, Lordship, probably after taking into account her evidence, order was passed. my lord.
Yes, yes.
Because unless the bank employees, most of the cases, not in all cases, my lord,
Mm.
their also involvement is also there. Lordship, because amount is too large, my lord, 11 lakh.
11 lakhs of
No,
rupees.
that's all right. It may be crores also, but where is the material to implead her?
Leave it to Lordship's discretion, but since he is the
No, not discretion.
employee of the bank, my lord.
Mhm.
And in
Merely
the
because
bank of
she
branch
is an
manager,
employee of the bank, you cannot implead her. There must be specific material. Heard, mister, what is your name?
S.J. Sharma.
Learned counsel for the petitioner and also heard Madam
And
B.
your
Bhuya.
Lordship, one aspect, that account was there in the UBI branch.
Yes.
wherein this person was working as a branch manager.
Yes.
Yes, my lord. That is one of the factor your Lordship may take into account. UTI bank,
Jakalabanda.
Jakalabanda branch account আছে।
Hmm.
So she being the branch manager of that branch, my honorable trial court has rightly issued the order to replace them. And they should
Okay, all
exercise
right.
the power.
All right.
I'll leave it to lordship.
For respondent number 1. And Mr.
The one.
A. Devan, learned counsel for the respondent number 2. Correctness or otherwise of the order dated 17/3/2021 passed by the learned subdivisional judicial magistrate Koliagor in PRC case number 232 of 2017, registered under section 420, 468, 409. Is challenged in this petition under section 482, read with section 379 and 401 of the Code of Criminal Procedure. It is to be noted here that by the impugn order dated 28/1/2019, the learned court below has invoked the jurisdiction under section 319 CRPC and impleaded the petitioner as one of the accused in the aforementioned case. The background facts leading to filing of the present petition is briefly stated as under. On 8/9/2023, is it 23 or 2016?
16,
16.
16.
And this page number 14 is the FIR?
14 is the FIR.
One Lolit Borgohai of Hatbor Boregaon, Jokolabanda, lodged on FIR with the officer in charge Jokolabanda PS to the effect that his mother, Srimati Bimola Gohai, availed government pension in her account, which was maintained in the United Bank of India, located at Jokolabanda. Jokolabanda. And since 18/6/2016, some culprits have withdrawn a sum of rupees 10 lakh from the account of his mother through ATM. But no ATM card was issued by the UBI Jokolabanda branch in the name of his mother, and his mother never applied for the same. Upon the said FIR, the officer in charge, Jokolabanda PS, registered Jokolabanda PS case number 129 of 2016 under section 420, 468, 409 IPC. And thereafter, investigation was carried out, which culminated in submission of charge sheet, being charge sheet number 31 dated 31/3/2017 against 3 persons namely Montu Hussain, Bipul Soikia, and Srimati Ruby Kotoki. Upon the said search, the learned court below has taken cognizance and issued process to the accused persons. And on appearance of the accused persons, the learned court below has framed search against the accused persons under section 420, 468, 409 IPC. Thereafter, the learned court below has examined two witnesses, namely Shri Lalit Borgohain and Srimati Bimola Gohain. Bimola Gohain. And after examination, no, after recording of the examination in chief of the aforesaid two witnesses, the learned additional PP of the learned court below had filed one petition under section 319 CRPC for implementing the branch manager and the cashier of the UBA, Jokalabanda branch, where the victim has maintained her bank account. Thereafter, hearing the learned additional PP, the learned court below has allowed the petition and issued summon to the branch manager, UBA Jokalabanda and cashier of the said bank to appear before the court below and to face trial. Thereafter, the petitioner, who was the branch manager of Jokalabanda branch of UBA, has approached this court by filing the present petition challenging the correctness or otherwise of the impugned order dated 28/1/2019. Mr. Sharma, learned counsel for the petitioner, submits that the impugned order dated 28/1/2019 suffers from manifest illegalities, and that the learned court below has invoked the jurisdiction under section 319 CRPC without there being any materials against the present petitioner. Referring to a decision of Honorable Supreme Court in the case of Hardeep Singh versus State of Punjab and others, reported in 2014, 3 SCC, page number 92, Mr. Sharma submits that in the aforementioned case, Honorable Supreme Court has held that the test that has to be applied while invoking the jurisdiction under section 319 CRPC is that more than a prima facie case is exercised at the time of framing of search is required to be made out, and sort of said satisfaction the jurisdiction of section 319 CRPC cannot be invoked. Cannot be invoked. Mr. Sharma, referring to one order, one judgment. No, no, referring to judgment of the learned court below dated 14/11/2023 submits that the learned court below has acquitted all the accused persons, including the present petitioner, from the charge under section 420, 468, 409 IPC, though the proceeding against the present petitioner was stayed by this court by order dated 27/7/2021. Mr. Sharma further submits that the impugned order fails to withstand the legal scrutiny, and therefore it is contended to allow the petition. Ms. B. Bhuya, learned additional PP, submits that though the name of the present petitioner is specifically mentioned by the PW 1 and 2, based upon which the learned additional PP of the learned court below has filed a petition under section 319 CRPC. And though the learned court below has not reflected in the impugned order dated 28/1/2019 about his satisfaction for invoking the jurisdiction under section 319 CRPC, yet the fact remains that the present petitioner was the branch manager of Jokolabanda branch of UBI, and during her tenure, a sum of rupees 10 lakhs was withdrawn from the account of the victim. And as such, according to Ms. Bhuya, the learned court below, the impugned order passed by the learned court below suffers from no infirmity or illegality, and therefore it is contended to maintain the same. On the other hand, Mr. Devan, learned counsel for the respondent number 2, submits that the learned court below has not recorded the satisfaction upon which he has invoked the jurisdiction under section 319 CRPC against the present petitioner. Mr. Devan further pointed out that this court was pleased to stay the proceeding against the present petitioner, and she did not face the trial before the court below, and as such, the judgment passed by the learned court below acquitting the present petitioner is not at all sustainable in the eye of law. Having heard the submission of learned advocates of both the parties, we have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 28/1/2019, which is read as under in the italics. Accused persons are present. PW1 and PW2 are present. They are partly examined, and their further examination in chief is reserved as per suggestion of learned additional PP, who submitted one petition under section 319 CRPC for impleading the branch manager and the cashier of the UBI, Jokolabanda branch, where the victim has been maintaining her saving bank account. Next para, heard, considering the necessity of impleading the said person as accused. Also peruse the materials on record. Next para, accordingly, PR is allowed. Let summon be issued to the branch manager, UBI Jokalamanda, and cashier of the same bank to appear to answer the charges level against them. Fix 22 to 2019 for appearance. A bare perusal of the aforesaid order reveals that the learned court below has not recorded its satisfaction as to whether there is any necessity of invoking the jurisdiction under section 319 CRPC and whether any prima facie case is made out against the present petitioner or not. It appears that merely on filing of the application by the learned additional PP, the learned court below has invoked the jurisdiction under section 319 CRPC against the present petitioner. The law regarding invoking of jurisdiction under section 319 CRPC is well settled by Honorable Supreme Court in Catena of decisions. In the case of Hardeep Singh, which in brackets Honorable Supreme Court in paragraph number 105 and 106 has observed as under 105. Power under section 319 CRPC. The proposition of law laid down in the aforesaid case for invoking the jurisdiction under section 319 CRPC is that more than a prima facie case as exercised at the time of framing of search, but sort of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. And in absence of such satisfaction, the court should refrain from exercising such power under section 319 CRPC. In the case in hand, having gone through the impugned order, I find that the learned court below has not recorded its satisfaction in arriving at a decision to invoke the jurisdiction under section 319 CRPC. I have also gone through the evidence of the PW 1 and 2, based upon which the learned additional PP has filed a petition before the learned court below for invoking the jurisdiction under section 319 CRPC. And it appears that nowhere in their statement, nowhere in their evidence, nowhere in their examination in chief, PW 1 and PW 2 have whispered any word against the present petitioner. In that view of the matter, merely on the basis of filing of a petition by the learned additional PP, the learned court below ought not to have invoked the jurisdiction under section 319 CRPC. Thus, examining the impugned order dated 28/1/2019 in the light of the principle laid down by Honorable Supreme Court in the case of Hardeep Singh, this court is of the considered opinion that the impugned order has failed to withstand the legal scrutiny. And accordingly, the impugned order dated 28/1/2019 stands set aside and quashed. In terms of above, this petition stands disposed of.
Lordship, my submission, my lord, although the PW2 has not mentioned the name of the present petitioner, it can be recorded as such, my lord.
Okay.
But she is the branch manager
Okay.
of the particular branch, my
We have
lord.
mentioned
My lord. No, her name was not taken by the.
no about the branch manager. We have mentioned.
Yes, But her name was not taken by PWP.
Obligation.
Item 6 for bail hearing.
May please, your lordship. Lordship, today is 56 days behind the bar, your lordship. And on the last occasion, the CD was received, but they were asking for FSL report, which was not received at that point of time. The allegation is regarding recovery of some fake currency notes from the possession of the petitioner, your lordship. Admittedly, all the fake currency notes have been seized, recovered. I don't know what the FSL report reveals, but otherwise I find that it is a case under section 489C, which is bailable and cognizable in nature. 489 and B are not attracted also. Even otherwise, 56 days behind the bar as on today.
How many days?
56. Arrested on 9/11/2023.
So Borwa, you received the case diary.
For the case that we have received lordship along with the FSL report. And
Then what is indicated in the FSL report?
the fake currency note.
Fake currency note.
Fake currency, 97,000 fake currency note recovered lordship from both the accused person.
Said amount was received by the petitioners from one Asmat Ali. After selling some agricultural products, which I have stated in paragraph number 4, your lordship. FIR is at page number 12.
What is this VTC Mathakua? This petitioner number 3?
No, it is not, it is a residence of Fulgata Part 3 actually.
Acha.
He has come down in lordship. There are two petitioners.
FIR is that page number?
FIR is at page number 12, your lordship.
So it was recovered from their possession. And the FSL report confirmed that those were fake Indian currency note. So where is your case?
This position, only from their position it has been found, your lordship. Now, this is a case under 489C, your lordship. If the lordship takes the 489A, B, and C of the IPC. 489A basically says that if
Yes, Boro, is there any material against them?
My lord, it attaches lordship 289 B lordship. It is using a genuine forged or counterfeit currency note or bank notes. My lord, whoever sells to or buys or receives from any other person or receives traffic in our or uses as genuine any forged or counterfeit currency notes or bank notes, knowing or having reasons to believe the same to be forged or counterfeit, shall be punished with imprisonment for life or with imprisonment for either description for a term which may extend to 10 years and shall also be liable to fine. Now, this counterfeit currency lordship, it was in their knowledge that it is a fake currency lordship.
Is there any material to show that they have manufactured those notes?
Manufacturer, my lord, that is not, my lord, reflected clearly from the case diary, but they are using it, lordship.
Well, is there any material of using the same as
No, my lord,
genuine
because
currency
it was
note?
recovered from their possession, lordship. For what purpose they are carrying them otherwise, lord?
But that is I have stated in
It is
paragraph
not
number
that,
4, your
lordship.
lordship. Otherwise, lordship will go through section 489C. If they have used it or in some shop or some other places saying that these are genuine, your lordship,
Mm.
then section 489B will be, and section 489C, your lordship will see. Possession of forged or counterfeit currency notes or banknotes. Whoever has in his possession any forged or counterfeit currency note or banknote, knowing or having reason to believe the same to be forged or counterfeit, and intending to use the same as genuine or that it may be used as genuine, shall be punished with imprisonment of either execution for a term which may extend to 7 years or with fine or report. This has been made as a cognizable and bailable offense, your lordship. Allegation is that the amount had been found in their possession. And they have received the said amount. I have given the, in specifically in paragraph 4, the names, details, and address of the persons from whom we have received the said amount, your lordship. Otherwise, 56 days behind the custody and whether further custody that may also be looked at. There is anything else that they were in the business or they were counterfeiting or they were making these notes.
Yes, can I go to the case diary?
My lord.
Heard Mr. M.S. Laskar, learned counsel for the accused, and also heard Mr. R.J. Borwa, learned additional speaking for the state respondent. This application under section 439 is prepared by accused Gulab Hussain and Hazrat Ali, who are languishing in Jailazut in connection with Dhoguri PS case number 468 of 2023 under section 489A, 49B, 49C, 34 IPC since 9/11/2023. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by ASI Sanjay Chaudhary of Dhuburi PS on 9/11/2023. The essence of allegation made in the FIR dated so and so is that on that day, the informant on that day at about 3 p.m., the informant, along with other staffs, apprehended one Gulab Hussain and Hazrat Ali and recovered from their possession 97,000 of suspected fake Indian currency note and accordingly seized the same, preparing seizure list in presence of witnesses. Mr. Laskar, learned counsel for the accused, submits that the accused are behind the bar for last 56 days and that the case was registered under section 489A, 489B, 489C yet. The offense under section 489C IPC is attracted here in this case is the counterfeit, allegedly counterfeit notes were recovered from their position, and the said offense is a bailable offense, and therefore it is contended to allow the petition. On the other hand, Mr. Arjay Borwa, learned additional PP, has produced the case diary before this court and submits that the IO has collected sufficient incriminating materials against the petitioner, no, against the accused persons, and the FSL report indicates that the notes recovered and seized from the possession of the accused persons are fake Indian currency note. And therefore, Mr. Borua contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also peruse the case diary along with the FSL report available therein. The FSL report dated 1/12/2023 indicates that the notes recovered and seized from the possession of the accused persons are fake Indian currency note of 500 denomination. Case study indicates that the accused person should deal with the business of fake currency not on commission basis. The investigation is still going on and some of the culprits are yet to be arrested. And enlarging the accused persons on bail at this stage will hamper the investigation, and accordingly, this court is of the view that this is not a fit case where the privilege of bail can be granted, and the petition is dismissed. Case there be returned.
Obliged, Lordship.
Item number 7. Yes, the injury report was called for. We have not received the case diary, Lord.
Mr. RJ Barua, learned additional PP submits that though the case diary and injury report was called for by order dated 12/12/2023, the same has not yet been received. And accordingly, it is provided that Mr. Barua shall produce the case diary along with the injury report on
19/1. 19/1.
19. No, sorted
Before.
before Bihu.
Then my note 12 was.
12.
Yeah.
Okay.
Number 8,
Where this should not be. Lordship, city was called for, Your Honor, and I'm along with MR report.
But the search is submitted, Lordship.
Under section.
The section has not been, my note mentioned, Lordship, but on the 13th number date has been provided. Search number, Lordship, 184 of 2023, dated 20/12/2023.
Barua, the sections are necessary to dispose of this bail application. Can you collect the sections under which the search sheet was filed?
At 2 p.m.
2 p.m.
item 9,
Item 9 also search is submitted.
My lord, here, Saturday is 5/11 and 58 days in custody, my lord. May I pray that, my
50?
lord, the same 58 days in custody. My lord, may I pray, 5/11 is there, my lord. So may I pray, under what section the charge sheet has been submitted?
That we have to obtain instruction also because the report was the section.
So
has-
under which sections the case was registered?
376, 5/11, 354B. My lord, incident is that of a in a railway coach. Tried to do immoral act.
Oh, Barua, you confirm it?
At 2 p.m.
2 p.m.
Yes. Okay.
item 43,
Here, background of this case is that the petitioner is an advocate, practicing advocate at Guwahati, Lordship. In the month of October, one person came to his chamber and asked to obtain a certified copy of a particular mutation order. Accordingly, he applied for that certified copy of the mutation order before the circle office disposed. And after that, the official informed that there is no such mutation order has been passed. And after coming to light of the said incident, the circle officer conducted an inquiry and found that the somebody, by using the official ID outside from the outside computer system, has obtained such mutation illegally without approval of the circle officer. So accordingly, the circle officer, after consulting with the deputy commissioner, lodged an FIR that is at Annexure page 26, Lordship, before the cyber PM. Lordship, got it?
20?
26, Lordship.
Yes.
Yes, Lordship. That the official ID has been used by somebody outside from the computer system of the circle office without naming anyone, Lordship. So after register, may I read?
Not necessary.
Next. Granted interim protection, Lord. Page 29, Lordship, Annexure 5.
Yes.
After that, he appeared before the IU Cyber PS and recorded his statement on 2/12/2023. Hereafter, on 11/12, the petitioner was again called by the Cyber PS for interrogation, and he accordingly visited the Cyber PS, where he was kept for the whole night. And the next day, the family members were intimated he has been arrested in another case with the same set of allegations. That FIR is at page 16, Lordship. The genesis of both the FIR is the same particular mutation order, Lordship. So after registering that, he was produced before the judicial magistrate and paid for 14 days police custody, and he was 5 days in police custody, and 2 days 23 days, Lordship. In the FIR of page 16, Lordship, the IU of the Cyber PS has lost this FIR, subsequent FIR at page 16, Lordship. A reference is there, Cyber PS case number 12 of 23 under section 120B 419 420 IPC so and so. And that mutation application, this reference number is also the same with that of the earlier FIR also. The contention of both the FIR allegation, there's an illegal mutation by cell deed, and the concerned person who has done this illegality has been arrested, the computer operator and the Moinul Haq. And the Moinul Haq, the advocate Moinul Haq also arrested in 2 cases, and in both the cases he has been granted bail by this honorable court at the motion stage itself, actually, before the vacation. Actually. The petitioner is no way involved in the incident. Only allegation is that in the forwarding report, Lordship, at page number 20, Lordship, allegation against the present petitioner is that in the second paragraph, third paragraph, Lordship, page 20. Lordship, got it?
Yes.
During investigation, it has been learned that one case has been registered at Cyber PS, that is earlier PS case number so and so, so and so. In this case, one advocate, Muhammad Moinul Haq, already arrested by investigating officer. During interrogation, accused Moinul Haq stated that advocate Muhammad Safiur Rahman Mullah, that is the present petitioner, accomplice of Romain Modahi, was pursuing the case of Moriam Bibi at Circle Office, Dispur Revenue Circle. Advocate Muhammad Safiur Rahman Mullah took 2 lakhs rupees from the land mafia Romain Modahi for administering so and so a Betkusi Gaon. So and so, collect the certified copy of the statement of accused Moinul Haq. So he has been arrested on the basis of the statement made by Moinul Haq. And admittedly, the petitioner admitted that he has applied for the certified copy on instruction of his client. Apart from that, there is no involvement of the petitioner, Lordship. And already behind the bar for 23 days, Lordship.
Yes, Mr. Borla.
My lord, he has been implicated, my lord, typically on the statement of the co-accused Moinul Haq. He is also one of the advocates. Now, Lordship, as per his statement, Lordship, he has done some, my lord, the mutation of the case, my lord, on the basis of fake and false, my lord, cell deed, Lordship. Certificate copy of fake and false cell deed, Lordship. And he has done, my lord, the mutation work in the circle office. That is the, my lord, allegation against him by the co-accused, Lordship.
And the law is good. The Moinul Haq has been granted by this honorable court at the motion stage, Lordship. I have the copies, Lordship. He has been arrested in 2 cases, cyber PS as well as in the Gorshuk PS also. Several PS has been registered lordship. The computer operator who has done this illegally, he has also been granted bail lordship in connection with the cyber.
Yes, Borwa,
No, this is the material against him, lordship. My lord.
can I see the case there?
My lord, my lord.
And there is material against him.
Lordship.
Mm.
We have concerned witness is the Latmondal. He has also been arrested. His statement is vital, Lordship, here in this case.
Mm.
Because whether he has applied for the mediation or not, whether there is any
No,
involvement.
but apart from that, there is also a statement of the accused himself.
But
Mm.
what's that one? Lordship, considering the length of detention, is the practicing
What length
advocate.
of detention? Investigation is still going on.
He has been interrogated in 5 days police custody, Lordship. Prior to that, he has recorded his statement in the twice. After that, he was arrested in this new case, Lordship, in Crime Branch PS case, Lordship. So considering the length of
So,
detention,
what is the name of that Mandal? Lat Mandal?
Babdhan Das, Lordship. Whether his involvement is there or not, that will reflected from his statement, Lordship.
Is the accused also known as Baharul Islam?
No, that is different advocate lordship. Because Baharul has applied for that mutation application.
But, there are materials.
So considering the length of detention and that he is the advocate, strictness of the strict condition may be imposed, also he may be allowed to go on bail. He is a resident of Guwahati lordship. Having his minor children and he is suffering from different ailment lordship. I have annexed all those medical documents also. And the main accused has been granted bail lordship.
Who is the main accused?
Moinul Haq lordship. And the computer operator Trubhajyoti lordship. Trubhajyoti Borman lordship.
Heard Mr.
Yes, second.
Learned counsel for the accused and also heard Mr. Arze Borwa, learned additional briefing for the state respondent. With application under section 439, services prepared by accused Saifur Rahman Mullah.
Sofiu.
Safiur Rahman Mullah, who has been languishing in Jail Hazard in connection with crime branch PS case number 09 of 2023 under section 120D, 419, 420, 468, 471, 409 IPC. For grant of bail, who has been languishing in Jail Hazard since 12/12/2023. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by Inspector Sandan Das of Cyber PS on 4/12/2023. The essence of allegation made in the FIR dated so and so is that during investigation of cyber PS crime number, no, case number 12 of 2023 under section 120B 419 420 IPC, read with section 66C 66D IT Act, and edit section 409 468 471 IPC. It has been found that some fictitious mutation orders were passed by mutation file number MET/DIS/23/23/9042/OMUT. And it has also been found that the mutation order was passed on the basis of fake deed, being deed number 6268 of 95, dated 31/12/1995 in the name of buyer Ansar Ali. And the name of seller Jotindranath Goswami and Devendranath Goswami. Of Polton Bazar. The learned counsel for the accused submits that the accused is a practicing advocate and he is behind the bar for 23 days, and that some of the co-accused have already been granted bail by this court in BA number 4372 dated 14/12/2023 and in BA number 4639 of 2023 dated 21/12/2023, and that the accused has been interrogated for
5 days. 5 days.
5 days, and his further custodial detention in the interest of investigation may not be required, and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Borua, learned additional PP, has vehemently opposed the petition. And producing the case diary before this court, Mr. Borua submits that the IO has collected sufficient incriminating materials against the accused, and therefore, Mr. Borua contended to dismiss the petition. Having heard the submission of learned advocates of both the parties, I have gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It appears from the case diary that the IO has collected sufficient incriminating materials against the accused. Investigation is going on. And some of the co-accused are yet to be arrested. And enlarging the accused on bail at this stage will hamper the investigation, and therefore this court is of the considered opinion that this is not a fit case where the privilege of bail can be granted at this stage.
Lordship, the anticipatory bail application is fixed on 8, Lordship, in connection with the cyber PS. So instead of dismissing, Lordship, fix both the matter on 8 of January, Lordship.
Pardon?
In the cyber PS, petitioner has been granted anticipatory bail that is fixed on 8/1, Lordship. So I pay for fixing both the cases on 8/1, Lordship.
No, this petition we are dismissing. Accordingly, the petition is dismissed, case ready be returned.
Tend to mention that. এবার আমি বুঝতে পারছি না যদি আপনি শুনে ঠিকই আছেন তাহলে আই যাবে হবো মই নাই মই ক'বলৈ মই হাইকোৰ্টত আছো মই তাৰ পৰা দেখা দি আহিছিলো মাতি তাৰে কিমান এই গোটেই বাকি আছে
মোৰ এটা চাপলি মানে হিয়াৰিঙৰ পাৰ্ট হাৰ্ট দেখুৱাত মানে পেৰেণ্টছৰ কাৰণে
মই কি জানো তোমাৰ পাৰিছে মই মই পইচা তোমাক কিমান তাৰমানে বেলেগ এটা আহিলে নেকি সেইটো প্ৰথমতে আহিছে মই ড্ৰয়াৰ পইচাটো আহিছে গম পাইছো এই দুটা কেছ পঠাইছো এটা আছে ডিআৰপিটো প্ৰজেক্ট চাই নেকি কোৱাচোন সেকশন কেইটা লাগে সাবজেক্ট বলে নহব বৰ্ডৰপুৰ ডিআৰপিটো সেকশন কেইটা লাগে আৰু পটাছে নাম্বাৰ সেকশন কেইটা লাগে সেকশন কেইটা আনা লাগে হোৱাটছআপ কৰি
আপোনালোকে কালি মানে এটা কেছ আছে ন এটা আছে ন চেম্বাৰৰ সেইটো আপোনাৰ দিছে না পেশেন্টটা
their own vehicle went to the house of a relative in Chalchali to know about the well-being. At the time, our car was stopped by the local village guard at Ramtial Kilati in Chalchali and robbed them with the money and mobile phones. The accused, not being satisfied in the grievous injury, at this grievously injured my husband with sharp weapons, from which my husband died. The accused, in a very inhuman way, killed my husband. The injured Hafizuddin is still under treatment. My lord, on the very day, an incident of cow theft occurred in the village, and the local village defense party thought that the deceased and his partners were the thief. So there was a scuffle, and the present petitioner was not even present on the day. He was a plumber, and on the very day he went to Palijuli for in regards to his work. CD was called for Lordship.
Borwa? You received the case diary?
Yes, my lord, we have received the case diary, Lordship, along with the postmortem report. Along with the postmortem report, Lordship, one person died.
Hmm.
My lord, the eyewitnesses has implicated him, Lordship. My lord, although specifically not mentioned that, my lord, how he is assaulted, Lordship, but here eyewitnesses has implicated him that he was also present, Lordship, in assaulting.
No, only remain present or he participate in the offense.
My lord, that is, my lord, my lord, it is mentioned that, my lord, he has mentioned the eyewitnesses, he has mentioned the name of 8 person, Lordship. And my stated that আৰু বহুতে মাৰিছে কিন্তু এই কেইজনে অলপ বেছিকে মাৰিছে. That is the allegation.
So, you have been granted the privilege of previous bail
Your Lordship.
on 1/6/2023.
Yes, I'm on insurance.
You appeared before the IO?
Yes,
When?
on the last occasion, this court, honorable court directed me to
He
appear again.
appeared, Lordship, in statement recorded, that I am from the case diary.
Hmm. So whether his custodial interrogation is necessary
My
for
lord, that part I leave it to Lordship, because my lord, the eyewitnesses has implicated him, Lordship. That is the statement of the eyewitness. But the one of the victim, Lordship, he has not implicated, although probably, Lordship, the victim, one of the victim, Lordship, injured victim, he has not implicated. This statement also recorded. Probably, Lordship, he could not identify the person, Lordship, who was assaulted.
So where is the statement of the accused?
My lord, it is in the later part of the case there is.
Heard Mr.
M.R. Sadiq.
Learned counsel for the applicant and also heard Mr. R.J. Boro, learned additional PP for the state respondent. Apprehending arrest in connection with Samaguri PS case number
6.
6 of 2023 under section 341, 326, 392, 302, 34 IPC. This application under section 438 services prepared by applicant Ali Hussein Ali for grant of period bail. The above noted case has been registered on the basis of an FIR lodged by on Marzina Khatun on 3/1/2023. The essence of allegation made in the FIR dated so and so is that on the night of 30/12/2022 at about 10 p.m. her husband Sohidul Islam along with Hafizuddin and Abu Siddiq proceeded towards Salsoli to know about the well-being of their relatives in her vehicle. And at Ramtila Ati in Salsoli, the Blaze Defense Party stopped them and robbed their mobile phone and the money, and also injured her husband by means of sharp object, for which her husband suffered damage, and also injured one Hafizuddin Ahmed who was undergoing treatment at Nagaon Civil Hospital. The learned counsel for the accused submits that this court by order dated 1/6/2023 was placed to grant the privilege of interim period bail. And pursuant to the said order, the applicant has appeared before the IO and a statement is recorded, and he has been cooperating with the investigating agency. And therefore, it is contended to make the interim order dated 1/6/2023 absolute in the same terms and conditions. Whereas Mr. R.J. Bora, learned additional PP, has produced the case diary before this court and submits that the applicant had appeared before the IO and his statement is also recorded pursuant to order dated 1/6/2023. But Mr. Bora submits that the witnesses examined so far has implicated the present accused with the offense alleged in the FIR, and therefore Mr. Borua has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It is not in dispute that pursuant to order of this court dated 1/6/2023, the applicant had appeared before the IO and his statement is recorded. And he has been cooperating with the investigating agency. Further, it appears that the IO has achieved substantial progress in the investigation of the case, and the case is pending for arrest of some of the co-accused persons. In view of the progress of the investigation, and also in view of the cooperation being extended by the applicant to the investigating agency, custodial interrogation of the applicants applicant seems to be not warranted in the interest of investigation, and therefore the interim order dated 1/6/2023 is hereby made absolute on the same terms and conditions. The case there will be returned.
Item 12,
Deeply obliged.
May it please your lordship. The 438 application, my lord, the petitioners are on interim bail, my lord. They appear, the statement has been recorded, my lord. Whatever, my lord, apparently there was a relation between the petitioner number one and the unfortunate girl who committed suicide, my lord. And eventually he was arrested, my lord. And subsequently he was released on bail. And this affair was logged when he was languishing in jail, my lord. You know. Okay.
Borua,
My lord.
you received the case diary?
Yes, we received the case diary, Lordship. My lord, there was love affair between the petitioner number one and the victim girl, Lordship. So they eloped, Lordship, and they were later on, they were caught, Lordship. Because my lord, the family members of the victim, Lordship, they were against the marriage of the petitioner and the victim girl. Now the petitioner was arrested, Lordship, and the victim was taken back to her house. Then she committed, my lord, suicide, Lordship. For the postmortem report, Lordship, reveals that she committed suicide, but it was final cause of death was not ascertained because the my lord, other examination was pending. Now the Lordship chemical examination report also present, Lordship, and no, my lord, no poison or any metabolisms were detected in the exhibit, Lordship. That is there.
So cause of death is
By cause of death, Lordship, in the postmortem report, Lordship, the ligation mark is non-continuous, Lordship.
not.
Non-continuous.
Oh, is it not suicidal?
It is suicidal, Lordship. That is
Acha.
non-continuous.
And my lord, when this affair was lost, one of the petitioner number one is in jail, was in jail.
Other petitioner, they are family members, Lordship, of the petitioner.
He was in jail, my lord. Eventually there was an affair, the petitioner was arrested, he was in jail. Then, my lord, the family members took the girl back, my lord, she committed suicide, and again this affair was lost, my lord. When he was in jail.
They have appeared, Lordship, statement recorded.
And her statement was also recorded at that time.
So you have been granted the privilege of previous bail.
What's it?
You have appeared before the IO.
Lordship, we have appeared.
When you have appeared?
My lord, in the case, under the specific date to the.
Heard Mr. S.M. Abdullah
My
Bill,
lord,
learned counsel for the
1996, Lordship.
applicants and also heard Mr. R.J. Borwa, learned additional PP for the state respondent. Apprehending arrest in connection with Soigao PS case number 87 of 2023 under section 306-34 IPC. This application under section 438 CRPC is preferred by 6 applicants, namely Mohammad Ariful Ali, Ashraful Ali, Rulia Begum, Amir Ali, Akiron Bibi, and Kudus Ali for grant of pre-arrest bail. The above noted case has been registered on the basis of one FIR lodged by one Atwar Rahman on 18/2/2023. The essence of allegation made in the FIR dated so and so is that on 4/2/2023 at about 10 a.m. in the morning, the daughter of the informant, namely Srimati X, within bracket name hotel, aged 16 years, was kidnapped by Mohammad Ariful Haq and kept her confined in the house of Kudus Ali with a view to marry her against her will, and also committed sexual intercourse with her against her will. Thereafter, his daughter returned home, and then Ashraful Ali, Ulia Begum, Amir Ali, Akiran Bibi, and Kudus Ali Akiran Bibi, not Kudus Ali, Akiran Bibi threatened her that after coming out of the jail, Ariful Haq will again kidnap her. And then, being left with no other option, his daughter committed suicide. The learned counsel for the applicant submits that the applicants have been granted the privilege of pre-arrest bail by this court by the order dated 9/6/2023. And pursuant to the said order, the applicants have appeared before the court and they have been cooperating with the investigating agency. And that they are nowhere involved with the offense alleged in the FIR, and they are ready to cooperate with the investigating agency, and therefore it is contended that the interim order dated 9/6/2023 may be made absolute in the same terms and conditions. On the other hand, Sir R.J. Borwa, learned additional PP, has produced the case before this court and submits that there was affairs between the victim with Ariful Ali.
Accused number one.
Ariful Ali.
Petition number 1.
And the family members of the victim have not approved the same and lodged FIR against Ariful Ali, upon which Soigao PS case number 71 of 23 has been registered, and Ariful Ali is arrested and forwarded him to the court. And thereafter, the victim girl returned to her parental home, and there she has committed suicide. Can I see the case diary? However, having regards to the nature of accusation and the punishment prescribed for the same, Mr. Borwa, learned additional PP has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record. And also, here is the case diary with the assistance of Mr. Borwa, learned additional PP. Was there any suicide note?
That I have not found in the case diary, Lordship.
But there is a report of one FSL.
FSL report regarding our handwriting.
Yes. Why? Yes, one suicide note. Is it not available here?
I did not find, Lordship, but I have to put through again.
The case diary also indicates that during the course of investigation, the IO has seized on suicide note of the victim, wherein she stated that she has committed suicide at her own will and that the boy is innocent. And the said suicide note was forwarded to FSL Kailipara, wherein the suicide note has been confirmed to be written by the victim. Where it also appears that the IO has achieved substantial progress in the investigation. And the material part of the investigation is almost over. Since the material part of the investigation is almost over, and since the applicants have been cooperating with the investigating agency, further custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 9/6/2023 absolute in the same terms and conditions.
Public
Case is
Item 13,
So item number 13, Lordship, we have received the case diary, Lordship. May I pay the matter be taken up on Monday, Lordship? I should not go to the case diary properly.
Mr. RJ Boro, learned additional PP submits that he has received the case diary today. And he pressed for listing the matter on Monday so as to enable him to go to the case diary. There is accordingly allowed.
Monday, Lordship.
Interim order dated
23/11/2023. 23/11/23. There is two interim, my lord. We are relying on the second interim.
Second interim dated 26.
23/11/20.
How to interim order was passed?
My lord.
How two interim order can be
My lord,
passed in one bail
my lord,
application?
Following the first interim, my lord, we approved the police station, but IO was not available during that time. Thereafter, my lord, considering that fact, this
So
honorable court
interim
has also
order
granted-
dated 26/6/2023 stands extended till then.
My lord.
item 14,
Made clear, Lordship. This is a 430 application, my lord. The petitioner is an interim, my lord. Petitioner has appeared before the IO and given a statement. So the FIR is just page 13. This is a case where the petitioner and the informant were in a relationship for several years, after which they had a breakup. Following the breakup, my lord, the informant has lost his FIR, everything arranged, my lord. It was a consensual relationship between the informant and the petitioner, and that is also apparent from the FIR. Page 13, my lord, will find that.
So Boro, are you received the case diary?
Yes, so we have received the case diary, Lordship, and my lord, in one of the informant statement, Lordship, he has stated that, Lordship, there were some love affairs, Lordship, then she got pregnant. Then the accused, Lordship, took her to some mandir, Lordship, then put her vermilion. Then, Lordship, her pregnancy was terminated by the accused person, Lordship. Thereafter, Lordship, there was no any, my lord, relation between them, but because he has avoided her, Lordship, and not keeping any contact with her. And refused to marry her, Lordship.
So what is the stage of investigation?
So the stage of investigation, Lordship, he has appeared pursuant to the interim order, Lordship. But his statement not recorded, Lordship. Why
That's
I'm
all right,
saying,
but,
Lordship, because the certified copy of the order I have found in the case there is.
but the material part of the investigation is over.
So statement of the witnesses have been recorded, Lordship. And only matter is yet to be recorded, is yet to be.
Why the case is pending then?
My lord, because my lord, why his statement not recorded, Lordship, it is not clear from the case there is.
Hmm.
Otherwise, my lord, we appeared and we also went to PM.
Heard Mr.
Yes.
S. Nawaz, learned counsel for the applicant, and also heard Mr. Arjay Borwa, learned additional PP for the state respondent. Apprehending arrest in connection with Obhayapura PS case number 256 of 2023 under section 417 376 IPC. This application under section 438 services prepared by applicant Sanjeev Kumar Das for grant of various bail. The above noted case has been registered on the basis of an FIR lodged by one Srimati X within bracket name withheld on 3/6/2023. The essence of allegation made in the FIR dated so and so is that there was a relation between the informant and the applicant, and promising to marry the informant, the applicant has committed. Applicant has established physical relation with her and on 22/12/2022 the applicant had taken the victim to Guwahati and put vermilion over her forehead at Kamakhya temple, and thereafter kept her in a rented house at Beltala. And thereafter he terminated her pregnancy, which she was carrying, by administering medicine. And thereafter he left Beltala and also stopped connection with her. Mr. Nawaz, learned counsel for the accused, submits that this court was pleased to grant the privilege of interim period bail by order dated 24/7/2023, and pursuant to the said order, the applicant had appeared before the IO and he has been cooperating with the investigating agency. And further, Mr. Nawaz submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that he is ready to cooperate with the investigating agency, and therefore it is contended that the interim order dated 24/7/2023 may be made absolute in the same terms and condition. On the other hand, Mr. Arjay Borwa, learned additional PP, submits that the applicant had appeared before the IO pursuant to order dated 24/7/2023, and his statement is also recorded.
Not recorded.
Not recorded.
But my lord, I have found-
his statement is not recorded. No, but his statement is not available in the case. However, Mr. Borwa submits that the IO has examined several witnesses here in this case. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also where is the case area with the assistance of Mr. Borwa, learned additional PP. In view of the materials, no, in view of the progress of investigation, and also in view of the cooperation being extended by the applicant to the investigating agency, his custodial interrogation seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 24/7/2023 absolute in the same terms and conditions.
I'm deeply obliged.
Bond court. Yes, madam, you have gone through the record.
Yes,
Yes.
there are materials.
Under whose
was
provision the case was registered?
420, 378, 120.
What is the punishment under section 370A?
Imprisonment of not less than 5 years, but which may extend to 7 years and with fine.
Is it compoundable offense?
370A, no, no. I don't think your lordship. It's a compoundable offense.
So not compoundable offense. So the respondent, you are for respondent number 2, 1.
Informant, victim.
So you have no objection. Respondent number 2. And state has no objection.
No, I don't say I have no objection because
Uh,
there are materials in the CD. I found materials in the CD. Even the medical board has been constituted and there's a report. Will lordship may kindly have a look at the materials against the.
No, that's all right. Material is there,
I know.
but she has no objection.
But lordship,
What?
since the other 370A.
Yes.
whether
No,
your
that's why they have approached this court.
I know.
Otherwise, they could have filed a petition before the court below.
Well, the allegation against me is that I have castrated along with the petitioner number 2. But the facts, you'll see the NHR. It is evident from the NHR, my lord, that she has undergone a.
So
process-
FIR is at page
medical
number?
FIR is at page number 16.
16. Forbid.
According to her, my lord, the incident had taken place on 10th of April 2019.
So state has objection then.
Lordship.
Okay, we will see. Heard, Mr. Your good name?
I don't think.
Learned counsel for the petitioner. And also heard Ms. B. Bhunya, learned additional PP for the state respondent number 1. And Miss Madam, your name? R. R. Soikia, learned counsel for the respondent number 2. Argument concluded, order reserved.
CDB retained, my lord. CDB retained.
Timing item 5. Timing item 5.
Please, your lordship. Here we have challenged the order, we just rejected our Jimma petition, of a vehicle, The vehicle is in custody, that case has been now charged sheeted.
So Mr. Kayal is absent. So let him come after some time.
Timing item A.
Matter searches submitted under section lordship 341, 323, 354, 506, 34 IPC.
341, 323.
354, 506, 34 IPC.
What is the number of the charge sheet?
184 lordship, 2023, dated
8423.
dated 20/12/2023.
Yes. Heard me, sir. Your good name?
Yes,
S.A.
yes, Deca.
S. Decca, learned counsel for the accused, and also heard Mr. R.J. Borua, learned additional PP for the state respondent. This application under section 439 service is prepared by accused Pintu Das, who has been languishing in Zelazut in connection with Potential Lumber APS case number 257 of 2023 under section 341, 323, 326, 354, 511, 379, 34 IPC. Since 28/10/2023 for last how many days?
Till today it is 68 days, Your Lord.
68 days.
Yes, Lord.
It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Debasis Roy, Sunny Roy. Page number 8 is the FIR.
Yes, Your Lord.
Shubham Sarkar and Sumit Sarkar. The essence of allegation made in the FIR dated so and so is that on 24/10/2023 at around 9:10 p.m. While he was returning from idle immersion of Rotkhola Sarbozanin Committee near R.J. Borua Road, one Pintu, Sagar, Biki, and Sandu, a resident of GMC New Colony, stopped his DA vehicle, being armed with knife, bamboo, and other sharp objects, along with 15-20 boys, and assaulted him and Ankit Roy, Sumit Sarkar and Shubham Sarkar, and Monty Sarkar and Sunny Roy. And Pintu Sunny Roy and Pintu assaulted Ankit Roy and Shubham Sarkar with sharp object, and he was assaulted with bamboo. And Pintu also assaulted Monty Sarkar and tried to outrage her modesty. And they have also snatched away the gold chain and mobile phone. His gold chain and mobile phone. The learned counsel for the accused submits that the accused is languishing in Zelazot for last 68 days. And that for the purpose of investigation, his further custodial detention may not be required. And therefore it is contended to allow the petition. Whereas Mr. R.J. Borua, learned additional PP has PP submits that though the case that he was called for, yet he has not received the same. And as per instruction, the investigation of the case has already been completed and search sheet being search sheet number 184 of 2023 under section 341, 323, 354, 506, 34 IPC has been laid before the learned court below. Since investigation of the case has already been completed and the accused is also languishing in jail as of for last 68 days. His further custodial detention, in the interest of investigation, seems to be not warranted here in this case. Now trial will start and the accused has to prepare his defense. Under the aforesaid facts and circumstances, this court is inclined to allow the petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the learned Chief Judicial Magistrate, Kamrup and the accused be enlarged on bail.
Timing item 9.
I apply.
My lord, 58 days in custody, my lord.
Yes, Borga.
And charges submitted under section 341, 376, 511, 354B IPC.
Let the scan copy of the record come. We'll see what materials are available against you.
My lord, petitioner is a CRPF personnel, my lord. He will face trial, he is duty bound, my lord.
That's all right. You will face the trial.
58 days,
But
58 days, my lord.
the allegations are serious in nature. Mr. R.J. Boro, learned additional PP, submits that though the case diary was called for along with the statement of the victim woman recorded under section 164 CPC, yet as per his instruction, the IO has completed investigation and submitted charge sheet, being charge sheet number
26/2023, dated 30/12/2023.
under section 341, 376, 511, 354B IPC. In view of above, it is provided that the registry shall call for the scan copy of the record along with the case diary, fixing the matter on Tuesday.
After vacation?
No.
On 11.
11.
11/1. 11/1. Obliged, my.
Timing item 5.
Chief, we have not received instruction yet. Allow us 1 week time to obtain instruction.
That information you could have furnished to the court on the earlier occasion.
Chief,
This piece of information could have been furnished to the court on earlier occasion in the morning hours.
Chief, I have asked my senior regarding this.
But it's a charge sheeted case, my lord. And the investigation is completed long back, charge sheet has been submitted, the petitioner is facing trial. So, the IO's report regarding this case.
Heard Mr. S.M. Abdullah P, learned counsel for the petitioner, and also heard Miss
M. Deka.
learned counsel appearing on behalf of Mr. S.C. Kaya, learned standing counsel for the NCB. While the matter was taken up during first hours, during first half, the Ms. Deka submits that her senior, Mr. Kyle, is in legs in another court and prays for listing the matter after some time. And when the matter was taken up at 2 o'clock, Ms. Dekka submits that the information so required by this court has not been received. And press for granting some more time. Here is accordingly allowed. Mr. S.C. Kyle, Learned Standing Counsel, is directed to remain present in the court on Monday at 10:15 a.m.
Obliged.
Item number 15.
I'm sorry, Lord.
My lord, here we have received the case diary, my lord. But without the medical report, my lord.
So why this matter was mentioned in the morning hours?
Because Lordship,
My lord.
matter of 326, Lordship, medical report was not there,
Medical report was?
not there. Lordship.
Yes.
My
Is
lord,
it correct?
No, my lord, medical report is not here.
Not there.
No. They are in interim, my lord.
No, interim all right, but the application was filed
Lordship, long back, Lordship, medical report is not there. Chief.
more than
My
6 months.
My lord, 24.
About 6 months.
Lordship, I waited for the medical report.
So what is the stage of investigation?
My lord, investigation is going on, my lord. Some of the, my lord, here opinion not received, my lord, medical report here referred to GMCH for needful, my lord. There are some prescriptions here, my lord. And the last entry was, my lord, also 25/9, my lord. Here it is said that medical report সংগ্ৰহ কৰি প্ৰতিবেদন দিয়াৰ বাবে যত্নবান থাকিম। Medical report is as per, my lord, in the earlier, not received, my lord.
Where is the FIR?
Lordship, the page 10, Lordship. The background of the case is that, Lordship, the
Page number?
page 10, Lordship. Own brother, Lordship, father is one side and other sons are there, Lordship, and other side, Lordship. Both sides have been lost, Lordship. This is the second FI, Lordship, against us.
So what is the statement of the victim?
My lord, here is the, my lord.
For that, Lordship, will kindly see page 16, Lordship. Lordship, the page 10 FIR date is 4/7/2023, Lordship. Kindly turn to page 16, Lordship, annexure 2. This is the FIR we have filed, Lordship. That was lodged on 1/7/2023, Lordship. First, we have lodged the FIR, Lordship. Thereafter, subsequently, they have lodged the FIR. And if father is in one side and his son is in other side, Lordship. That, we have fight between father and son and brother, Lordship.
The accused and the victims are brother.
Brother Lordship, father is in one side Lordship, again, and other side Lordship, his son is there Lordship, son and daughter-in-law Lordship. Both sides got injury Lordship, 326 registered in both the FIR Lordship.
Heard Mr. S. Moner, learned counsel for the petitioner, applicant, and also heard Mr. B. Sharma, learned additional degree for the state respondent. Apprehending arrest in connection with Soigao PS case number 304 of 2023 under section 341, 326, 325, 34 IPC. This application under section 438 services prepared by 4 applicants, namely Mungla Mia,
It's 83 years Lordship.
Abu Bakr Siddiq, Kulsuma Akhtar, and Miss Aklima Akhtar for grant of periods bail. The said case has been registered on the basis of one FIR lodged by one Sahiton Ahmed on 4/7/2023. The essence of allegation made in the FIR dated 4/7/2023 is that on 38/6/2023 in the morning, at about 10 a.m. in the morning, she and her husband Samsul Alam were walking in front of their house. And then then Kulsuma Akhtar and Miss and two wives of the two wives of Abu Bakr Siddiq, arrived at there and started picking up quarrel with them. Thereafter, Abu Bakr Siddiq and Mungla Mia also arrived at there, and Mungla Mia caught hold of her husband, and Abu Bakr Siddiq stepped on the right hand of her husband with sharp object and injured him seriously. And Ms. Kulsuma Akhtar and Aklima Akhtar also assaulted the informant and pulled her hairs. And when her brother-in-law Mohammad Mulan Haq came to save her, then Abu Bakr Siddiq rushed to cut him. Mr. Munir, learned counsel for the applicants, submits that this court was placed to grant interim protection to the applicants by order dated 24/7/2023. And pursuant to the said order, they have appeared before the IU and they have been cooperating with the investigating agency. Mr. Munir further submits that the applicants and the informant and her husband, father and sons.
Informant is the daughter-in-law of the petitioner number 1.
Yes.
Father-in-law, petitioner,
No,
number 1 is the
the
father-in-law.
quarrel is in between father-in-law
Yes,
and the son.
father-in-law.
And a cross case being Soigao PS case number. What is the number of that case?
That is
301?
PS 301 2023.
301 of 2023 under section 143, 341, 447, 354, 326 IPC has also been registered against the informant and her husband
In the same incident, same incident.
in
same
connection
dates.
with the same incident. In connection with the same incident. And therefore, no, and that custodial interrogation of the applicants may not be required in the interest of investigation, and therefore Mr. Monet contended to make the interim order dated 24/7/2023 absolute in the same terms and conditions. Whereas Mr. D. Sharma, learned additional PP, submits that though he has received a case diary, yet the injury report of the victim is not available in the same. Though the same was called for on several occasions. It appears from the record that the application was filed on 28 July 2023. An interim protection was extended to the applicants by order dated 24/7/2023. And since then, several opportunities have been afforded to the learned additional PP to produce the case diary along with the medical report, the injury report of the victim. Though the case diary is produced before this court, the injury report of the victim is not available in the same. Having considered the facts and circumstances on the record, this court is inclined to dispose of this petition in absence of the injury report of the victim. Admittedly, the informant and her husband is the son and daughter-in-law of the applicant Abu Bakr Siddiq.
No. Monglu Mia.
Monglo
Petitioner
Mia
number one.
is the son of Monglo Mia, applicant number 2.
One lot. One is the
Applicant
petitioner.
number 1, yes, applicant number 1. And Abu Bakr Siddiq is the son of Monglo Mia.
Brother lot.
Is the son of Monglo Mia.
Lordship.
And further, it appears from the case diary that the IO has achieved substantial progress in the investigation of the case. And the same is pending only for collection of the injury report of the victim. The applicants have also been cooperating with the investigating agency. And in that view of the matter, their custodial interrogation in the investigation, in the interest of investigation, seems to be not warranted here in this case. And therefore, this court is inclined to make the interim order dated so and so absolute in the same terms and condition. In terms of above, this AB is disposed of, CDB returned.
Item number
Much
16.
obliged, Your Lordship. Much obliged.
My lord, may kindly see affair page 8. Here, my name is not there, and I am a constable, my lord. I posted at Titawar. Thing is this, my lord, some antisocial boys killed a mentally retarded person, and those boys have been arrested by police. When the incident was taking place, I was on leave. That is my home place, my lord. So I was on leave. I went there and asked the boys that you don't take the law and order in your own hand. Hand over the person if you suspect him to be a criminal to the police. But the boys has assaulted him badly and he succumbed to the injuries. Now, as I asked those boys not to assault this person, then they became angry with me, and out of wrath they also told my name.
Now, my lord, I am a constable. It was my duty to say that don't take the law and order at your head. So thereafter, my lord, I have approached this honorable High Court. This High Court has granted me interim bail. And after obtaining interim bail, I went to police station. I am on bail now. I have given my detailed statement that this is the situation. So only I came on that particular day for leave. And during that time, the incident happened. I don't know what is in the city, but my function is only that I asked the boys not to assault this person. The boys became red and thereafter they told perhaps my name. In affair, my name is Novetia.
Mr.
I have also annexed my
Sharma?
identity card.
My lord. My lord, here. Several witnesses also examined, my lord. Here, first, my lord, I came to my lord, PM report, my lord. PM report, my lord. It was.
Oh,
killed-
that's all right.
lord,
There is
brutally
no
killed.
dispute that the person
My
concerned
lord, my lord, brutally
died.
killed, my lord. Giving several
But
injuries, my lord.
is there any material against the applicant?
My lord. That's why I played. It is a witness and other co-accused people. I have flag mark, my lord.
This witness simply stated that he has seen the applicant.
The place of occurrence.
Yes.
My lord. There are the other co-accused, my lord, statement, my lord. I have flag mark.
He is co-accused, the other
Co-accused.
person is
My lord, I have seen.
Tapan Das.
No, my lord. Other, my lord. All the co-accused stated that he is involved in murder. One of the accused stated that he assaulted through a road, Kathor Batam. I have flag mark, my lord.
My lord, the name of the arrested persons are in page 13. My lord. 7 persons were arrested. Page 13.
Mr. Sharma,
My lord.
this kind of language is developed by Assam police.
My lord, that is difficult to for us also, my lord. অসমীয়াটো ইংলিছত দিব লাগে আচলতে ইংলিছ কথাটো হ'ব মই কওঁ মই কওঁ I have the statement of two landowners.
There is material against you, Mr. Mahmood.
My lord. My lord, what my lord, Tulendra Das, he has been arrested by police, that is page 13. So lordship is aware about by the
No,
statement.
one Nikhil Das,
My lord,
witness,
my lord.
and one Tulendra Das. Tulendra Das is a co-accused.
And he has been arrested, he is in now, but at present, I don't know, but he was arrested, he was forwarded. And he has given some statement against me on the ground that I told them something hardly that you cannot take the law and order in your own hands. Kindly see my identity card, page 14, annexure 3, my lord.
Oh, that's all right. You are a police personnel.
Police person. Now, my lord, at the cost of my service, whether I can involve like in a crime like this, my lord. And moreover, whether custodial interrogation is necessary in my case, because I am a constable always available under their jurisdiction and their custody. Whenever they would require, I will appear. So my custodial interrogation may not be necessary. I have also cooperated with the investigation. Immediately I went on bail. In that view, my lord, nowadays, my lord, service is dearer than life, my lord. Shall I take any such step which may cause injury to my service or to my life, to my family? Any condition lordship may kindly impose, I am ready to cooperate. But if I am arrested, my service will go, and in that case, my lord, when the purpose of investigation can be achieved, lordship is aware about the Supreme Court judgment, when the purpose of investigation is achieved by other means, then custodial interrogation normally should not be granted in exceptional cases. And more so when the person concerned is a police. And since last 8/9/23, I am on bail.
Were there any weapon of offense was you seized?
Perhaps not, my lord. Perhaps not, my lord.
Heard Mr. Mahmood, learned counsel for the applicant, and also heard Mr. P. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Lonka PS case number 399 of 2023 under section 120B 302 IPC. This application under section 438 services prepared by applicant Bodhiram Das for grant of previous pay. Above noted case has been registered on the basis of an FIR lost by one Muhammad Sibul Haq on 13/8/2023. The essence of allegation made in the FIR dated so and so is that his mentally retarded brother, namely Hibzur Rahman, was missing since last 12 days. And on 13/8/2023 at noon, he was informed by police that his brother was killed by some culprits on 12/8/2023 at night, suspecting him to be involved in the case of a theft of cattle. Mr. Mahmood, learned counsel for the applicant, submits that the applicant is a police person, and on the relevant date, he was in his residence at, from which place he hails from?
Village is my lord Bamungao, under Lonka PS.
In
But he was
Babangao
at
under
Pitao.
Lanka PS. And he is no way involved with the offense alleged in the FIR. And hearing Halla, he went there and he asked the culprits not to assault the victim, and that he has been granted the privilege of interim period bail by this court by order dated 8/9/2023. And pursuant to the said order, the applicant had appeared before the IO, and he has been cooperating with the investigating agency. And his custodial interrogation, in the interest of investigation, may not be required, and therefore it is contended to make the interim order dated 8/9/2023 absolute in the same terms and condition. On the other hand, Mr. B. Sharma, learned additional PP, submits that the IO has collected sufficient incriminating materials against him. And the postmortem report of the victim indicates that the cause of death was due to hemorrhagic shock as a result of head injury and other injuries sustained in the body. And therefore, Mr. Sharma contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary. With the assistance of Mr. Sharma, learned additional PP, and also perused the PM report. It is not in dispute that the applicant has been granted the privilege of previous bail by order dated 8/9/2023, and pursuant to the said order, he had appeared before the IO, and he has been cooperating with the investigating agency. It also appears from the case diary that the IO has collected some materials against the present applicant. However, in view of the progress achieved by the investigating agency, and also in view of the cooperation being extended by the applicant to the IO, his custodial interrogation seems to be not warranted here in this case. And therefore, the interim order dated 8/9/2023 is hereby made absolute in the same terms and condition. In terms of above, this AB stands to dispose of, CDB return.
Item number 17.
May pleasure lordship. On the 438 application, my lord. FIR at page 9, my lord. The FIR was lost, my lord, in the month of November, my lord, and when the incident took place in the month of January last year, my lord. And my lord, in the FIR itself, it is written, my lord, that the FIR was lost after an FIR was lost by the present petitioner against her relatives. My lord. Actually, the informant is the daughter-in-law. Page 9 is the FIR, my lord. FIR was lost on 2/11/23.
So, who is this petitioner?
It is the father-in-law, my lord. The allegation is that, my lord, that
The 164 statement
We
is
have
there?
received the case and 164 statement.
my lord, 164 statement, she will, my lord, implicate me, my lord. But
Hmm.
my lord, allegation is that, my lord, she came to depose as a witness in the case which the father-in-law lost against her relatives, my lord. And she has released that a false case has been lost against her relatives by the present petitioner, my lord. And hence she came, and that too, there is a delay, my lord, of nearly 10-11 months, my lord. And when she came from Hyderabad, she has to depose in this case as a witness, my lord. She has lost this present case that my father-in-law said that is there. Krishna is a retired school teacher, my lord, aged about 67 years, my lord.
Pardon?
Krishna is a retired school teacher, my lord,
Mm.
aged about 67 years, and this affair, my lord, was lost, my lord. Only when she came back from Hyderabad to depose in a case, which I have lost against her relatives, my lord, and she has lost this case against me, my lord. That too after a gap of more than 10 years, 10 months, my lord.
The problem is that there is no point for disbelieving the victim at this stage.
But my lord, this affair is a counter blast, my lord.
What counter blast?
My lord, lordship may kindly see, my lord, in the affair itself, she has revealed. Or affair that in the last page, then, my lord, last week when I was in Hyderabad, then I came to know that my father-in-law falsely lost the case against Babul Sangmai and Pradeep Purva, etc., who are the neighbors of my husband, and before Bamun Bari, subsequent the same was raised as Moran. I returned back to my parental home, my lord. Considering that the age of the petitioner, my lord, and the delay, my lord, of the 10, my lord, more than 10 months, my lord. After the alleged incident also, my lord, she stayed in the same house, my lord, till June, my lord. The incident happened, my lord, in the month of January, my lord. And she left the house on 25/6/23. The month of June, my lord. So the alleged incident also, my lord, my lord, she was dead there, my lord. At that stage, there was no whisper from her side, my lord. As a retired school teacher, my lord, 67 years of age. The other person, my lord, the son, released by the police, said the 498 was against the police. So the 498 is also there, my lord. The police has released them on police bail. But as 376, allegation is against me, my lord. So I'm before your lordship.
Our statement is consistent under section 161 and also 164 six. Heard Mr. S.M. Abdullah P, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Moran PS case number 108 of 2023 under section 498A 376 506 34 IPC. This application under section 438 CPC is prepared by applicant Hirakanto Sangmai for grant of respite. The above noted case has been registered on the basis of one FIR lodged by Srimati X name hotel on 2/11/2023. The essence of allegation made in the FIR dated so and so is that she got married with Gaurav Sangmai, son of Hirakanto Sangmai, in the year 2016. Thereafter, lived together with her husband in her matrimonial home. After the marriage, her husband, her in-laws subjected her to both physical and mental cruelty, and also did not provide her food, for which her daughter suffered malnutrition and died. And in the month of January 2023, after the birth of her second child, her father-in-law, Hirakanto Sangmai, while her family members were not present in her home, entered into her room and committed rape upon her. And also threatened her not to disclose the said incident to anybody else, and also threatened to kill her and her daughter, killed her daughter, and to drive her out from the matrimonial home. The learned counsel for the applicants submits that the applicant is a retired person of 66 years old, and that the allegation level against the applicant are false, and that the informant left the matrimonial home after picking up quarrel with her husband, and thereafter the applicant has filed one case against one Bobul Sangmai and Pradip Borua of Bamunbari, upon which a case being Moran PS case number 107 of 2023 has been registered. And the present FIR is the counter plus of the said case, and that the applicant is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Investigational PP has produced the case area before this court and submits that the IU has collected sufficient incriminating materials against the applicant in connection with the allegation made in the FIR, And in our both statement under section 161 and 164 CPC, the victim has implicated the present applicant and therefore Mr. Sharma has opposed the petition. But having heard the submission of learned advocates of both sides, I am going to put the petition and the documents placed on record and also carries the case diary with the assistance of Mr. Sharma, learned additional PP. The case diary indicates that the IO has collected sufficient incriminating materials against the applicant. In our statement under section 161 as well as 164 CPC, the victim has implicated the accused with the offense alleged in the FIR. The offense is serious in nature. Investigation is still going on. And at this instance, it cannot be said that custodial interrogation of the applicant is not required in the interest of investigation. Under the aforesaid facts and circumstances, this court is of the considered opinion that this is not a fit case where the privilege of anticipatory bail can be granted to the applicant, and accordingly the petition stands dismissed. Case diary be returned.
Item 19.
Please, Lordship. My lord, I am, we are on interim lordship. My lord, here CD notice, my lord. From Boko, my lord.
Mr. B. Sharma, learned additional PP submits that he has not received the case date and press for granting him some more time. Fair is allowed. List the matter on when?
My lord. 19th, my lord.
Till then, interim order dated 1/12/2023 shall continue.
Item 20.
20 and 21, same FIR. FIR is base 7. Informant daughter committed suicide. He written a suicide note stating that these two persons mentally tortured her. Therefore, they committed suicide. This two persons was a lover of the girl. My lord, here we have received a case there, my lord, but the suicide note not received, my lord. Suicide note and PM report not received, my lord. That is necessary, my lord. Purely suicide. Say that suicide note was written and before father himself that he committed suicide. PM report and suicide note.
Mr. B. Sharma, learned additional PP submits that though he has received the case diary, that the suicide note of the victim and the PM report
Right.
is not available in the case diary and price for granting him some more time to produce the same. There is accordingly allowed. List the matter on when?
22nd.
My lord.
When?
22nd.
22nd.
No, solve that.
In 19, my lord. 19.
19. 18. Why not 18?
18.
Well, reopening, my lord. That's after
On
new
18?
reopen. 19.
19.
19. There is no interim.
No, therefore we have been fixing
My
for
lord.
that.
That's why lordship.
21. Item
21.
21.
Same.
2021 same.
23. Item 23.
My pleasure, Lordship. Mr. Look at the application, Lordship, apparent face, my lord, student, my lord. My lord, CD not received here. My lord, this is the second time my lord has CD not received. Most of the accused my lord granted anticipatory bail before the Honorable High Court.
Pardon?
Most of the accused my lord granted anticipatory bail.
By?
My order dated my lord 13/12/23.
By this court or the court below?
Honorable Justice P.J. Shetty, my lord.
After perusing the case diary?
After perusal of the case, my lord, only
Let
one.
the case diary come or
My
we'll
lord,
consider your
302 is here,
parole,
my
sir.
lord. Only one accused, my lord, admitted it there, only one accused, my lord. That will be written from the case there, my lord. 302 is here, my lord. I have the order, my lord.
So based on our learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Sorma shall produce the case diary before this court on 12.
12, my lord. Who will try, my lord?
24,
Wait, please, your lordship. Lordship, 438 bail application, lordship, case diary was called for, lordship. My lord, here, it was sent for up-to-date CD, my lord, along with medical report, my lord. It was not received, my lord. It was earlier rejected, my lord. Yes, my lordship called for the up-to-date case report because last occasion, lordship, medical report was not placed, lordship.
From which PS?
It's from Panbari, Sriram.
So based on our learned additional PP submits that he has received the case diary.
Not received.
No, he has not received the case diary. And press for granting him some more time. There is allowed to list the matter on when?
18.
18th. On that day, learned additional
Right.
PP shall produce the case diary before this court.
25,
Wait, the 438 application log. CD was called for. CD received. So we'll find the FIR at page 16 of article 304B, lordship. Now all the adult members, lordship, are in arraigned as accused. And it is number 2, lordship. I'm the brother-in-law.
FIR is at page number 15.
15, lordship, article. I'm accused number 2, the brother-in-law, lordship. The prime accused suspect, lordship, accused number 1 and 3, the husband and the father-in-law, they were arrested. I have annexed the page 17 is the forwarding letter, lordship. They were released on bail after validity of bail period whatsoever. This petitioner is a practicing advocate, lordship. He practices at district court of South Salmara, lordship. Yes, and reside there about, it is about 30 kilometer, 25 to 30 kilometer away from the native village. And this petitioner, he had never been in domestic relationship since his joining in 2019, lordship. So, after 7 years of marriage, lordship, this incident had taken place. They had 2 children.
After?
After 7 years. Although it is written 6 years.
So what is the requirement of 304B?
7 years. It
7
has to
years.
be But
Within
as per
7 years?
Within 7 years. But as per my information, the marriage took place in 2017, so most likely 7 years was over. That is not the association, but I was not in a domestic relationship. Since 2019, page 10, lordship will find my certificate issued by Bar Council. I am a practicing advocate. I'm practicing at Mankachar, lordship, Harshing area. And it is around 25 to 30 kilometers away from the native village. The prime suspect, Lordship, husband and the mother-in-law, they were arrested and they were detained for 90 days. So custodial interrogation of this petitioner most probably is not required for further investigation of this case.
Yes, Sarma, is there any material?
My lord, from the statement of the complainant, my lord, it was revealed that, my lord, all of the accused persons physical and mental torture, my lord. Thereafter, my lord, after investigation, several witnesses examined, my lord. Thereafter, IO has one note, my lord. That is revealed.
Very general type of statement was probably tried to implicate each and every adult member of the family.
Main allegation is against husband and father. Main allegation against the husband and
They were arrested.
Father-in-law.
Case 17, Lordship will find the forwarding letter.
several cases are there.
Heard Mr.
Jadal.
Jed Alam, learned counsel for the applicant, and also heard Mr. P. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with SSMPS case number 292. Under section 304B 34 IPC, this application under section 438 services prepared by applicant. Asarul Mullah alias Asarul Islam Mullah for grant of previous bail. The above noted case has been registered on the basis of an FIR lost by one Ramesh Uddin on 2/10/2023. The essence of allegation made in the FIR dated 2/10/2023 is that his daughter Saina Khatun got married with one Akidul Mullah about 6 years back. And she was blessed with 2 children. And his daughter informed him that his daughter was subjected to physical torture by Akirul Mullah, Asarul Mullah, Sukur Ali Mullah, Horiman Bibi, Habil Mullah, and Kabil Mullah. And on 1/10/2023, his wife Jamila Begum went to the house of the accused persons to take her back, but the accused persons refused to grant her permission to accompany his wife. Thereafter, on 2/10/2023, at about 6 a.m. in the morning, Sukur Ali Mullah informed him that his daughter committed suicide and she has been taken to Fulbury Hospital. He then went to the hospital and found her daughter lying dead. The learned counsel for the applicant submits that the applicant is a practicing lawyer of South Salmara Bar Association and that he is no way involved with the offense alleged in the FIR. And the main suspect in the case is the husband and father-in-law, and both of them were arrested by police and forwarded to Jail Hazard on 3/10/2023. And therefore, Mr. Alam contended that the privilege of pre-arrest bail may be extended to the applicant. Whereas Mr. B. Sharma, learned additional PP, has produced the case study before this court and fairly submits that the allegations are against the father and husband, and both of them were arrested by police and forwarded to Jail Hazard. Whereas, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also produced the case diary with the assistance of Mr. Sharma, learned additional PP. It appears from the Annexure 1 at page number 10 of the petition that the applicant is a practicing advocate. Practicing advocate, and that the case diary indicates that the main suspect of the case is the is the husband and father-in-law of the victim, and they have been arrested by police and forwarded to Jail Hazard by Annexure 2. No, Annexure 3. Annexure 3 at page number 17 of the petition. 17 of the petition. In view of the materials collected so far in the case diary, especially the note of the IO, dated 17/10/2023, and further considering the fact that material part of the investigation is almost completed, and there remains to collect the FSL report only. Come on, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with case number so and so under section so and so, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM South Salmara without prior permission. In terms of above, this evidence dispose of CDB return.
26.
May I please know? FR is at page number 16, my lord. CD was followed.
Lordship, he, planned something to some.
Make this lordship.
Yes.
I've been instructed orally, my lord, to appear in this case. I am for the victim in this case, my lord. I am yet to receive my Vakalatnama. But
Yes.
I have some materials which is there.
Pardon?
I have some materials which are there in form of some documents which I have been
Yes.
provided today morning, my lord. My lord, please just if I will allow, because the CD is there, so I do not want to obstruct this honorable court. But my Vakalatnama is not been there on record. If my lord will allow me to submit orally, then I'll assist this honorable court, my lord.
Yes.
Page number 16, my lord. It is the FIR.
Yes.
My lord, though there is an allegation of gang rape against me. You know, sir, and has been conducted in my shop, behind the room of my shop. The only proof that I have to prove my statement is the CCTV footage. Annexure 2 is the certificate that I have annexed, stating that whatever has been derived. So the CCTV is the correct statement. And I have the copy of the pen drive. I have a pen drive which can substantiate the fact, the statement which is made by the accused herein, by the informant, is completely false and fabricated.
Forensic. Yeah. What is taking relied on?
So you are relying upon the CCTV footage.
Yes, ma'am. I'm relying on that. The
Uh,
specific date
CCTV footage was installed
In my
in
shop.
which place?
in my shop.
In your shop.
Yes, it is specifically
The
mentioned.
occurrence took place behind the
Yes.
behind your shop.
Yes, it is attached room behind my
Whether
shop.
CCTV footage was there in the other room where the offense took place?
No.
No.
The only point that I want
Then
to
how the CCTV footage will advance your case?
my lord, the date which is mentioned herein, that is 4/11/2023
Mm.
at 8 p.m. The specific date and the specific time. If your
Mm.
lordship sees that,
Mm.
it will be clear that on that particular day, the informant was not present in my shop.
Mm.
If her presence is not there on that particular day, how the occurrence of that particular incident may happen. That is my vital question.
So duration of the CCTV footage is from which point of time to which point of time?
Lordship, though I'm having the pen drive where it contains the entire.
You tell me the duration of the CCTV footage.
Sorry, my lord.
Who collected it? You collected it?
No, my lord.
Oh.
There is a technician certificate which is attached, my lord, page number
Hmm.
18. He is the person who have actually collected.
So
it.
one certificate is there.
Yes, my lord.
He had not mentioned there.
He has also mentioned about the start timing 17 and timing 23.
From 4/11/2023 recovered. On 6/11/2020 backup start times 17:08.
6 hours. 6.5 hours.
6 and
half hours, total duration of time of 4/11/2023
from which point of time?
on 6. Start time is 17, end time is 23:29.
Start time is
It is from 5 p.m.
5.
5.
Whether the footage was seized by police?
Not their information on verify.
It was not seized by police also. And it is from some technician certificate.
Not even some forensic.
Also.
So what is there in the CD?
Also here, the medical report is there. And also, the 164 statement is also there, Lordship, and along with some witness who saw the victim in that place, where she was said that she was injured by these two persons.
So
We have-
injury report is there.
Injury report is there, but not in that, it is the private injury is not there. But simple injury is there or physical injury.
Which part of the body?
Not been done yet.
Is there any injury over her left hand?
Left hand, yes. That is left hand part. It's a dorsal apparent of left hand. The simple injury, what kind of weapon inflicted is a blunt. Lordship, may kindly produce the CD.
Is there any injury over her neck?
I have photographs now.
Yes, Lordship. Anterior aspect of neck. That is also simple injury.
And the medical report is also available regarding this.
Yes, yes, yes. That part also available.
Will my lord, shall I also submit the documents which I have, my lord?
Yes.
Collected is
Collected. Please.
When the occurrence took place?
4/11 on 2023.
My lord,
Yes.
as the learned counsel had just said, there is a minor injuries which is referred in the CD, but the entire
Not,
process.
it appears not minor.
Yes. Even though some injury, my lord, I am referring to a case where there is an allegation of rape to me. So if you are going to a case and thinking a rape, it is obviously a forceful conduct.
Pardon?
My lord, the conduct of the accused, which she is trying to refer here, even in the FIR, is a completely forceful conduct of the accused persons. So what I'm trying to say here, my lord, though there is an injury, but the injury which is referred there, as the sections which is put on me, is about the gang rape. And the injury which was supposed to be sustained, if I'm supposed threatening, see have used it, they have threatened. So when I'm threatening somebody with the rope, it should be in such a way that there should be so much of pain and hurt that you should feel. But the pain and the suffering which it is referred in the CD, as stated right now, is not that so deep. It is somehow in a minor stage, as referred by the council here. And second, my lord, she has been, as she has mentioned here in the FIR, that she was dropped in the nearby road area. And there is, well, the case is nothing about that she has been threatened, or if you say something, I'm going to kill you, nothing kind of threatening, but the
No,
initial
this
stage,
is only prima facie material.
my lord, but I'm relying on
Prima
this.
facie materials are there.
Yes. But there is no evidence
And
of
the
such-
injury report indicates that she got injuries over her left hand and over her neck. And the same is corroborating the facts mentioned in the FIR.
Yes. Yeah, for that reason, my
So
lord,
at this is only we want the prima facie materials.
my lord, that's the reason why I'm referring to the CCTV footage, because
No,
the
that
only-
cannot be believed because had it been seized by police and produced by police, then it would have been different. Now, where is the guarantee that the video was not edited by the technician? And in the meantime, it is not manipulated. Where is the guarantee?
The guarantee is not there, my lord, but the certificate is there. Just he's
Maybe.
referring his license number
Maybe.
and everything. Because that is the only way initially which was available to me to come before this honorable court with a clean hand to show that this is the picture, and the only evidence that I have is this CCTV footage.
Okay. Heard Mr. What is your name?
K Vishwakarma, my lord.
Pardon?
K Vishwakarma, on behalf of Mr. SP Chaudhary.
Learned counsel appearing on behalf of Mr.
SP Chaudhary.
Learned counsel for the applicants, and also heard Mr. Kabosho, learned additional PP for the state respondent, and Mr.
AB Day for.
A.B. Day, learned counsel appearing on behalf of the informant.
Informant.
This application under section 438 CRPC is preferred by two applicants, namely Sandipan Chaudhary and Partho Das, who have been apprehending arrest in connection with Silsor PS case number 2105 of 2023 under section 342, 326, 376D IPC for grant of bail. For the grant of periodic bail. The above noted case has been registered on the basis of one FIR lodged by one Srimati X name withheld on 5/11/2023. The essence of allegation made in the FIR dated so and so is that on 4/11/2023 at about 8 p.m. she went to the grocery shop belonging to Sandipan Chaudhary, alias Sunny, to make payment of a sum of rupees 2,000 and also to purchase some other materials, other grocery materials. And after receiving the sum of rupees 2,000, the brother-in-law of Sunny, namely Partho Rohit Das, forcefully taken her to a room situated in the backside of his shop. And tried to commit rape upon her. And as she has resisted, accused Sunny took out a knife and assaulted over her left hand. And Partho Rohit Das also pressed her neck, causing injuries over her neck, and snatched away one gold chain weighing one body, and also thereafter committed rape upon her one by one. The learned counsel for the applicant submits that the applicants are innocent and no way involved with the offense alleged in the FIR. And in support of his submission, the learned counsel for the applicants have produced one pen drive containing the CCTV footage of the shop of the accused Sandipan Chaudhary alias Sunny, and the said CCTV footage is supported by one affidavit. One certificate issued under section 65B of the Evidence Act. And the said CCTV footage has negated the presence of the informant in the shop of the applicant at the relevant point of time. And further, the learned counsel for the applicant submits that the allegation in the FIR level in the FIR are not at all believable, and therefore it is contended to allow the petition. On the other hand, Mr. Boisha, learned additional PP, has produced the case diary before this court and submits that injury report of the victim is available in the case diary, and the injury report indicates that the victim sustained injury over her left hand and also over her neck, and the same corroborated her person in the FIR and also in the statement under section 161 as well as 164 CRPC. and that sufficient incriminating materials are collected in the case diary against the applicants, and therefore Mr. Busho has opposed the petition. On the other hand, Mr. Day, a learned counsel for the learned counsel appearing for the informant, has produced some medical document along with the photographs of the victim woman in respect of her sustaining injury over her left hand and also over her neck, and submits that the offenses are serious in nature and the applicants are not entitled to get pre-arrest bail in such serious cases, and therefore it is contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone for the petition and the documents placed on record, and also peruse the case diary with the assistance of Mr. Busho, learned additional PP. The case diary indicates that the IO has collected sufficient incriminating materials, and he has collected the medical report of the victim, and the same indicates the injuries got by the victim over her left hand, also over her neck. Moreover, she has implicated both the accused, both the applicants with the offense alleged in the affair in both her statement under section 161 as well as 164 CPC. The offenses are serious in nature. An investigation is going on. And having regards to above, this court is of the view that this is not a fit case where the privilege of pre-arrest bail can be granted to the accused persons. And accordingly, the petition stands dismissed. Case diary be returned.
Lordship, Lordship, in the certificate provided by the technician, here in the annexure part, no section is mentioned.
No?
No section is mentioned. Only a simple.
No, usually it is issued under 65.
Yes, yes.
Obliged, my lord.
Oh, you can. Okay. এইকেইটা ইয়াতে ৰাখি থব।
That is your option. This is 438 application. The FIR your lordship will find at page number 13. The allegation in this case is that the petitioner used to give some indecent gestures to the information. This was 1 month ago. And on 31/10/2023 at about 5 p.m. Milord, while her husband was not at home and she was in her house sleeping, Milord, then the petitioner entered into her house and committed rape.
Page 17 is the FIR?
13 Milord, 13.
What is 17?
17 is the FIR filed by the present petitioner. That FIR was lost earlier, Milord, and as a counter, Milord, the present FIR came to be lost against the present petitioner. 13 the FIR in respect of which I am seeking pre-arrest bail.
Page number?
13 Milord, 13. May I read, Milord?
No, is it page 17 is the vernacular of the page number?
Milord, page
13.
number 13, Milord, annexure 1. Page number 13.
What is page number 17?
17 is the FIR, Milord, another FIR, Milord. That is.
Have you gone to the record?
So that is the vernacular, Milord. I'm sorry, Milord. That is the
Mr.
vernacular.
Counsel,
I'm
don't
sorry.
try to mislead the court.
No, Milord, I'm sorry. I was referring to the type copy of the FIR. I'm sorry, Milord. This is the vernacular of the present FIR. Milord. May I read, Milord?
Number 18, if your lordship is pleased to peruse page number 18, my lord.
Hmm?
1A. The incident is alleged to have occurred on Lord 31/10/2023, my lord. But so far as the GD entry of the concerned outpost is concerned, my lord, it speaks that, my lord, the FIR was lost only on 2/11, my lord. And the FIR does not disclose the reason of the delay, my lord. This is one aspect. And then if your lordship is pleased to peruse annexure 2, my lord. Vernacular, your lordship will find at page number 23.
Yes, Mr. Bosio,
Yes, Lordship, in
what
this
is
case-
there in the case diary?
Yes, case diary we have received, Lordship. Lordship, here, Lordship, the two numbers of affairs are there. One is earlier lodged by the accused,
Hmm.
and then thereafter another by the present informant. And here both the affair on the incident took place on the same day, Lordship. The first affair, it tells that there is some dispute in the roadside, and after that that FIR was lost to recover the present accused petitioner. And the second FIR stated that in the night, with some ill motives to outreach the modesty and all, the present accused petitioner, he went there. Lordship, here the investigation is under progress. 164 statement is also there, and some witness are also examined in this regard. Lordship, I kindly peruse the city. I have already flagged marked.
Hmm. No, is there any material against the applicant?
Lordship, against the applicant, Lordship, no such, only one witness who is related to relative of the the informant. She has only one statement. Other than that, other witness, they said that they didn't observe all this thing. Then they have stated regarding the earlier affair.
Okay, the city. Yes.
Lordship, in the witness, Lordship, part.
Hmm.
So kindly peruse them. Yes, like. Also 160.
So the occurrence took place at 12 o'clock in the midnight. So where is the chance of getting eyewitness to the occurrence?
My lord, as per the FIR, my lord, it took place on 5:30, 5 p.m. my lord, at about 5 p.m.
But in her statement under section 164,
Yeah.
she stated that at midnight.
No, my lord, in the FIR, if your lordship is pleased to appear page 17, my lord, to make it clear, my lord. In 11,
It is in the
I may be-
midnight
I may
as
be
per
allowed
This is in the
164.
164 is that, Lord.
that my lord, on that day, my lord, I was admitted in the hospital, my lord, because I was beaten.
Hmm?
I was beaten, my lord, and I was there in the hospital, my lord. And the receipt, I have also submitted the NFP receipt for the medical prescription, my lord. And the medical prescription says that at about 5 p.m., my lord, I was in the hospital, not in the place of occurrence, my lord. That I was beaten, my lord, and my all the belongings, my lord, were forcefully taken away by the husband and the other relatives of the informant, my lord. Husband's family members, my lord. And the same also gets, my lord, transferred from the seizure list, my lord. And I sought for the Zimma of those, my lord, belongings, and Zimma was also granted. I have also annexed that documents, my lord.
Heard, Mr.
Yeah, Ali.
Learned counsel for the applicant and also heard Mr. A. Basya, learned additional PP for the state respondent. Apprehending arrest in connection with Waku PS case number 525 of 2023 under section 509 448 276 IPC. Edit section 394 IPC. This application under section 438 CRPC is prepared by applicant Noor Samad alias Noor Samad Ali for grant of previous bail. The above noted case has been registered on the basis of an FIR lodged by one Srinati X name hotel on to 11/20/23. The essence of allegation made in the FIR dated so and so is that on 31/10/2023 at about 5 p.m. in the afternoon, while her husband was not present in her house, and she was sleeping, then accused Noor Samad Ali entered into her room and caught hold of her and committed rape upon her. And she then raised hue and cry, and then the family members, her family members, apprehended him. and handed him over to the police station, at the police station. The learned counsel for the applicant submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and in fact, the FIR lodged by the informant is the counterblast of the FIR lodged by one Rabial Hussain,
Father of the petitioner,
father of the
present petitioner. Accused petitioner.
who is the father of the present applicant on 31/10/2023, and he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. Boisho, learned additional PP, has produced the case diary before this court and submits that there are materials against the applicant, and therefore Mr. Boisho has opposed the petition. After having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Boisho, learned additional PP. In view of the materials collected so far in the case diary, especially the statement of the victim woman recorded under section 161 CRPC, as well as 164 CRPC, and also considering the statement of other witnesses, this court is of the view that a prima facie case is made out for granting the privilege of peers bail to the applicant, and accordingly the petition stands allowed. It is provided that in the event of arrest of the applicant in connection with Baku PS case number so and so under section so and so, he shall be released on peers bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privileges, however, subject to the following three conditions. Last condition shall not leave the jurisdiction of JM First Class Baku without prior permission.
I'm obliged.
28.
May it please your lordship. Lordship, this is a 438 bail application, lordship, second time bail application, lordship. It was rejected, lordship, in the month of November, lordship. The FIR, lordship, will find on page 18, lordship. Specific allegation, 2 person, lordship. The 2 person has been arrested, lordship. The FIR on page 18, lordship.
What is the ground for filing this second
Now, lordship,
application?
subsequently the two arrested person released on bail. Now the question is only on the basis of the statement of the co-accused, lordship, he stated that he has handed over amount to this present petitioner, lordship. But he till date, lordship, could not substantiate that by any transaction, lordship, which will show in his account that the amount was transferred to this petitioner, lordship. Because, lordship, this petitioner well was in that at Lakhimpur, lordship. At that time, this petitioner number, accused number 1 used to meet this petitioner, lordship. So, lordship, now, lordship, this lordship accused, that is in FIR name accused,
No,
lordship.
whether the amount was handed over in cash or through this electronic
That,
transfer.
lordship, that informant, lordship, informant said, lordship, on page 19, lordship, informant said he has paid, lordship, cash 3 lakhs, 2 lakhs, 2 lakhs. That is to the accused number 2, not this present petitioner, lordship. He is not named in the FIR, lordship. This present petitioner is not named in the FIR, lordship. They were, lordship, manipulated and, lordship, forced the signature, lordship, that specific in the FIR, lordship. But there is no whisper against this petitioner. Only on the basis of the statement of the co-accused, lordship, this petitioner was arrested, lordship. Oh, sorry, lordship, this petitioner was apprehension of arrest, lordship. Now, lordship,
So, at this says, why should we disbelieve the statement of the co-accused?
only, lordship, he has to substantiate because of his statement, lordship, that is it, lordship, recorded before the magistrate, lordship, that is not there, lordship. Only 161 statement, lordship. Only
For the
only-
purpose of investigation, is it not sufficient?
Lordship, that is lordship, under lordship, he's tried to tarnish the reputation of this petitioner lordship.
Why?
Because,
Why?
because he has that position, he approached this petition lordship, he refused lordship. Now he has tried to implicate this petitioner
That
lordship.
is your defense case.
That's true, lordship.
You
I'm
argue at
standing
the
as a-
time of trial.
That's true, lordship. Now he's a government servant lordship. Because of his lordship false statement lordship, this petitioner is apprehension of arrest lordship. Because he is a government official lordship. No departmental action has been taken against this petitioner. No departmental inquiry has been made against this petitioner. No such complaint is raised against this petitioner lordship.
Yes, Mr. Borwa, what is there in the case diary?
Case there is the material is same also because lordship is already rejected the earlier bail application also. Now he has come for the second time also. But investigation is pending, lordship, my lord, the investigating officer has said that the appointment letter, he has sent it for, my lord, for report, whether it is genuine or not. But already, when it is a fake, then the appointment letter, lordship. What is the use of, my lord, sending? I do not know. That is the report of the, my lord, investigating officer. Last entry of the investigation. lordship. Otherwise, lordship, police is, my lord, like, police is searching this person, lordship, because he has been named by the co-accused.
Search it submitted.
No, police is searching, lordship.
Oh, searching.
The
Acha.
person. Because lordship, the informant said she has handed over the money to the two person, lordship, that are, and those are her brothers, and they have given the money to this petitioner for regularization of her job, lordship. That is the allegation.
So why should we disbelieve the statement of the co-accused persons?
Exactly, lordship, this is the investigation stage.
Yes.
Only because lordship, as a lordship submitted, he just tried to tarnish the reputation of this petitioner lordship.
Why? Why they
Because
will
lordship,
tarnish?
he has approached this petitioner lordship, he refused that lordship. Because that lordship, that's why lordship amount was specifically mentioned in the FIR, that amount was specifically given to this two person lordship who are named in the FIR, not to this petitioner lordship. Only because of lordship, tomorrow lordship, anyone come and say, I have handed over some such and such money to that person lordship, then that person will be in
No,
trouble.
no,
lordship.
there is a specific allegation against you. You
That
are
is
the
a-
employee of that office.
There is there any independent notice, lordship? Is there any transaction lordship which is took place in presence of any other person lordship? Is there lordship any evidence that lordship I have received that
What
amount,
evidence?
lordship? Because lordship he has said lordship no specific lordship that amount is transferred to
No,
my account, lordship.
during investigation stage, the statement of the accused is sufficient.
That
It may not be
lordship,
sufficient
even
during trial.
my statement is also recalled because lordship this punishment is below 7 years lordship. 41A notice was not issued lordship. Which is petitioner lordship. At least he placed his case before the IO lordship. 41A notice was not given lordship. And no departmental inquiry has been made against this petitioner lordship. If such things is happened lordship, they said there is a racket lordship. And they lordship and the forwarding
That
report also
will
lordship.
not even from the case there, lordship, whether development.
That's lordship. If such an allegation is against this person, definitely department will take action against this person lordship.
So after rejection of the first application, there is no development in the investigation.
But there is no development of materially same lordship, only it is pending. What I have found from the last entry, that here IO has sent this appointment letter for the report for genuineness of the appointment letter. When it is already, my lord, it is already stated that it is fake, lordship. That report is, my lord, is not necessary. My lord, IO can either complete the investigation and IO can do, my lord, proceed with the further investigation.
Now, lordship, whether that was lordship sent by me or not, that has to be taken into consideration, lordship. That appointment letter, lordship.
Pardon?
That appointment letter, it is not signed by me, not prepared by me, lordship. The person,
No,
lordship.
that is your defense case.
Yes, lordship. I'm standing for defense, lordship.
But on the basis of the statement of the two accused persons,
Only one accused, lordship.
no.
But Lordship, no departmental action has been taken, Lordship, if such a thing
No,
has
no,
happened,
no,
Lordship.
no. That is
Whether
not
Lordship, I
a,
have made any endeavor to.
that is not a point for
Lordship,
granting you
because
anticipatory
only
bail.
because of the statement of the co-accused, Lordship, this.
Why should we disbelieve him?
Because
Disbelieve them.
it is not recorded under 164, Lordship, it is recorded under 161, Lordship.
During investigation stage, that is sufficient. Mr. Borba, can I see the case diary?
My lord.
So this page number 30, paragraph number 1, 2. In one, instead of KK Parasar, it is Arjay Borba, learned additional PP, page number of point number 2, paragraph number 2, 3. Then after 4, you take down. Up to 3. Mr. Chaudhary, learned counsel for the applicant, submits that this is the second anticipatory bail application filed by the applicant. And the first one was rejected by this court by the order dated 16/11/2023. Mr. Chaudhary further submits that the ground for filing this second application is that in connection with the aforementioned case, 2 accused have already been arrested and both of them are granted bail by this court. And that the applicant is innocent and no way involved with the offense alleged in the FIR, and no departmental proceeding has also been initiated against him. And therefore, Mr. Chaudhary contented to allow the petition. On the other hand, Mr. Arjay Borba, learned additional PP, submits that The IO has collected some material in support of the allegation made in the FIR, and the arrested accused persons implicated one of the arrested accused person has implicated the present applicant with the offense alleged in the FIR, and during investigation the statement of the accused is sufficient, and that investigation is still going on, and the fake appointment letter has already been sent to the FSL for examination, and therefore Mr. Borua has opposed the petition. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional bit. It appears that no much headway could be achieved by the IO in investigation of the case after arrest of two co-accused, namely Monindra Hazurika and one Devananda Saikya. Except, however, sending the fake appointment letter to the FSL for examination. In view of the materials so far collected in the case diary, and also in view of the ground shown by the applicant for filing this second bail application, this court is of the view that it cannot be said at this stage that custodial interrogation of the applicant is not required in the interest of investigation. In view of the specific allegation made against him by one of the co-accused, custodial interrogation of the accused seems to be indispensable in the interest of investigation, and accordingly the petition stands dismissed. Case diary be returned. The applicant shall surrender before the IO within a period of 1 week from today.
One more thing, no departmental inquiry has been initiated against the petitioner.
Pardon?
No departmental inquiry has been initiated against.
Already dictated.
Highly obliged.
From production list, item 1 for withdrawal. 1 and 2.
No, please, Your Lordship. I have instruction to withdraw this bail application.
Mr. S. Salim, learned counsel for the applicant, submits that he has the instruction to withdraw this application, and accordingly paid for allowing him to withdraw the petition. Here is accordingly allowed. This bail application is then disposed of on withdrawal.
Item 2.
Same, my lord.
Same order in item 2.
I am obliged, my lord.
Rest of the cases, you can.
May I make a mention, if your lordship kindly permit?
Yeah.
Item 34 from the hearing list, if your lordship can kindly take it on 12, lordship.
12.
It has come twice, there's a part heard matter, it could not reach lordship.
Okay.
Small issue is there, only 52A is there. Obliged.
Last day, 11. So on 11.
On 11?
Yes, big hearing matter and the last day. 34 on 11.
So, hearing matter.
Item 44, anyone from 44?
The other side?
The side is not present.
Absent.
And only for on one point, this
Yes.
court has had
Yes.
regarding sanction lordship.
Mm.
In the judgment of police reveals that well, that he is not in service. In the charge sheet also it was reflected that he is not in service. He was an ex-employee.
Ex-employee.
Ex-employee lordship. Okay, page number maybe if you lordship would like to.
Tuesday.
Otherwise.
Tuesday. So the other side is absent today. So let it come on Tuesday.
Next week.
Your Honor, similar
Uh,
prayer.
Pardon?
Item number 32, Your Honor.
30?
32, your lordship.
32.
Yeah, hearing matter, your lordship, the parthered matter, your lordship, parthered matter, your lordship, item number 32. Kindly matter be fixed on 19, your lordship.
30, you are in 32,
Yes, your lordship.
parthered matter.
On 19, your lordship.
Pardon?
On 19, your lordship.
19. Okay, 19.
Lordship, item number 29, my lord, no interim, my lord. Item number 29.
So, so on Monday.
My lord, item number 31, same matter, my lord, no interim matter.
Okay, okay.
Deeply obliged.